Item 1.
Item 1, Your Lordship, I am appearing for the appellant. Your Lordship, file is untraceable. If Your Lordship could direct the registry to give us a soft copy on a pen drive so that we can reconstitute.
We have a file here.
Yes, sir.
Give that file. Take that and prepare now. I will not give time. More than 23-year-old matter.
Your Lordship, 2 weeks time may be granted.
Take that.
No, Your Lordship, as per the noting, the requisites need to be filed for the LRs of OP number 5.
If they have not been filed, it abates. Matter abates by operation of law.
No. So it is a duty of the appellant to file the requisite for to issuance of the fresh notice to the OP number 5, LRs of OP number 5.
But you have not filed.
Because the file is untraceable, Your Lordship. That is the reason why I'm before Your Lordship.
When that order was?
Your Lordship, it is of 19th March 2025.
19/3/2025. Now you are coming after how many months to complain that you have no file?
Your Lordship, last chance may be granted, Your Lordship. 1 week time may be granted. We'll file the requisites and Your Lordship may list for this.
Take this and file a requisite now. For filing requisite, this is sufficient. In the evening, it should happen now.
Your Lordship, we need to prepare. I'm unprepared regarding for the hearing, Your Lordship.
Preparing?
Your Lordship, my time may be granted for preparation.
2002, man.
Your Lordship,
no time should be granted.
1 week time maybe.
No, I have to disobey the order of the Supreme Court.
Last chance, Your Lordship.
Correct. But you are very humble in saying. But I have to, if I accept that, I will be violating the order of the apex court. Now you take that file,
Your Lordship,
and do the needful immediately.
Your Lordship.
Yeah, accompany the lawyer along with the file. Somebody should accompany.
We can give the soft copies. We can give him soft copies.
Soft copies, Your Lordship.
Registry to furnish soft copy. Who alleges that, who says that file has been, his original file has been misplaced. First of all, requisites to be done within 2 days, failing which petition stands rejected on its own, peremptorily. Next.
Item 2.
The petitioner is seeking the release of the security deposit which has been illegally withheld by the opposite parties, despite completing the work and the final bill was issued. And that was released also. That payment was released against the final bill. Though in the tender process, after being successful, I had deposited.
Why? Who should read for you?
Your Lordship, I am preparing. Your Lordship, copy may be served, we'll see it.
2023 matter.
Yes, Your Lordship, we have not received the copy.
It has come up for the first time. Even in an identical manner, this Honorable Court has disposed of it.
Going to consider the representation.
No,
but you are not given copy of the petition to him.
Yes, Your Lordship.
The matter has come up for the first time.
First time.
Yes.
For admission, it has come for the first time
Yes,
after 2 years.
Yes.
What has happened to the registry?
That's para 2 in next page.
Emergent notice. Learned, what's your name, brother?
Milan Kumar, Your Lordship.
Sri Milan Kumar. Panel Council.
Central Government Council.
Central Government Council is requested. Accepts notice for copy number
1 to 3, Your Lordship.
1 to 3. Any other party? No.
No.
Well, if I may just add.
Matter lies in a narrow compass. Call this in the last week of December, 3rd week of December 2025. You give this with you and produce it on the day it comes.
Grateful.
Next.
Item 3.
Similar to minor soda.
Which is that? The date and other things. This sentence you have to change it with sentence is incomplete. Just ask someone, sir, and say, do this. So consider. Next.
Item 4.
In person.
Yes, fine, in person.
He is not here.
Very many prayers, Your Lordship and see.
Inspector General of to constitute a special investigation. What happened actually? What is the complaint?
Exactly. Even your lordship may see the prayer number 6. Next one. Commanding opposite party number 7 to install adequate street lights in Bapuji Nagar area and within 30 days.
Who is from party number 7?
Opposite party number 7, that is.
But anyway, the complaint should be looked into. That is his case. You accept notice and say something on that.
Yes.
Yes, Lanka accepts notice for copies. Call in the second week of January 26. Next.
Item 5.
May I please, madam. Lord, seeking UGC scale up pay, your lordship issued notice yesterday on item note 19.
Issued.
Excuse me.
For one and so one and good. Lovely GST requested to accept notice for 3. Emergent notice to. Who is the UGC?
UGC no one.
3, 4 and 5. Okay.
Item 6.
All along with WP number?
Have you?
Yeah. Next.
Item 6.
May I please, your lordship?
Yes.
The matter relates to unilateral decision of the opposite partner to contrary to resolution passed in 12th management committee members meeting of the board held on dated 10th September 2025.
Transfer order.
Yes, your lordship. Resolution number passed in 12th committee of management meeting held on 10th September 2025, wherein it was decided that local management committee member would take decision and prepare a list of the staff of the union to be transferred by conducting meeting at branch level, and the said report would be submitted before the opposite partner to for necessary action at his end. But contravening the decision taken by the board of director board meeting, flouting the said resolution, the opposite partner to
It's a society, cooperative society.
is
Is there cooperative societies act in your state?
Yes. They are having
Yes.
own panel
There is a
council.
cooperative society.
Society Act.
Then any dispute can be raised under
Before this honorable court, great court, on Article 2.
dispute. Give that cooperative societies act.
Yes, sir.
There should be mechanism for dispute resolution. no?
Yes, by a judgment of this honorable court, that this honorable court has declared that is within the Article 12 of the Constitution of India as a state.
It is a state under
Yes,
Article
yes.
12.
Yes, sir.
But all right. But if the dispute is resolution can be done under the provisions of which is the section?
67, I think.
67B. 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 And this dispute to tribunal. Constitution of cooperative tribe. The state government shall by notification. There is no constitution. Courts of law does not say anything. Arising in connection with the election of any of the disciplinary action taken by the secretary of the committee. Not because any question I can say that in dispute, all disputes arising in connection with the election of to the president. Issue emergent notice and stay as prayed for till next date of hearing. Learned the
State is not a party.
it is not a party. This interim protection is granted after looking into the provisions of section 67A of the Odisha Cooperative Societies Act in 62, and on the submission of the council for the petitioner that the subject society is an instrumentality of state under Article 12 of the Constitution of India.
Item 7.
May I please, Lordship?
Yes.
Lordship, petitioner is the public sector bank, Lordship. And this is the second round of litigation, Lordship.
I think question the order at Annexure 7.
Yes, Lordship.
What is that order? You have drafted the prayer correctly. All others, all verbose. So many words, issue notice, asking to show cause. If he does not show cause, or what he shows cause is not correct, then issue the all you have kept wonderfully prayer you have drafted. I should give you some relief. Wait. What is your what is that Annexure 7?
Lordship, may I place something, Lordship? By order of this Honorable Court and the finding of the Supreme Court in Sebeti to do, Lordship, sale certificate is not required under the Surface Act.
Huh?
Sale certificate is not required under the Surface Act, under the provision of the Surface Act, Lordship. Only to enter the book number 1 is sufficient, Lordship.
That's what correct. You're right.
But
Brother, that itself constitutes a title document is the decision of various high courts, including Karnataka High Court. Look into
Your Lordship, issue notice.
emergent notice. Matter lies in a narrow compass. This court is very happy to see that crisp prayer texted in the petition by Srimati.
Pragya Paramita Mohanty.
Right. And it is appreciable. Yes, next.
Item 8.
Obliged, Lordship.
Stop.
Item 8 regarding to RSFT method. She has disposed of the similar method. 8 and 11. Yes, we have to correct.
8 and
11.
11.
11 also, sir. All the matters.
this sentence completed. Someone in another judgment have completed that. Yeah.
Item 9.
Claim for promotion from accountant to section officer. Her claim is pending before the authorities.
24,925.
My page 40.
Write down. You consider that.
Annex 8.
This was I have one submission more, my lord. This was I have not sent it through post. In hand I have given.
You send one more by post.
My lord, that I want.
Short grievance with the petitioner is reflected in the prayer column, which is as under. Next question. Learned counsel for the petitioner submits that despite giving a representation dated 24/9/2025, a copy whereof awaits at Annexure 8, case of his client is not considered for promotion to the post of section officer, though she is he or she is qualified and eligible. First, Learned counsel seeks intervention of the Great Court in that direction. Next one. Learned AGA Mr. Banka, to any part about these, submits that there is no evidentiary material to vouch that the representation was given to the jurisdictional officer, and therefore, in the absence of that, the officials will face the difficulty. First, he suggests that if an appropriate representation is sent with vouching material, there would be no difficulty for considering the same in accordance with law and in a time. This is appreciated. Next one, in the above circumstances, petition is this board of preserving liberty to the petitioner to give an appropriate representation to the commissioner cum secretary, school and mass education department within 2 weeks. And if one is given, the same shall meet its weight at the hands of the jurisdictional officer within the next 8 weeks next following. First of all, contentions are kept open. Most of the solicit information. Next.
Item 10.
The petitioners are elementary teachers.
Not the minimum proportionate pension to the petitioner retired. You have drafted the prayer wonderfully. No verbose, nothing. No frill, no frock. Everything is so open to naked eye. Take notice.
Yes.
Okay. NECA accepts notice for two things I am observing. Whoever is preparing the brief beautifully, 5 marks. Whoever is speaking through the mic, 10 marks. What is meant by that, you don't ask. Giving marks means what? It's not giving me order, but will be heard. Yes. All of this.
All of these.
All of this. Okay. Next.
Item 11 has been disposed of. Item 12.
Matter under section 91 Code Act,
91.
91 and 92.
What it says?
The order of demolition.
Huh?
Order of demolition
Demolition.
issued by the Bhubaneswar Municipal Corporation.
For violation of the building bylaws.
That was later on found by the appellate authority. Here, my lord, before going into the facts of the case, there, my lord, a division bench, another case was placed before the Honorable Division Bench, where the constitutionality of the power.
Don't disturb. Go out. What do you think? Do you have any value of the court? Let's see. Yeah.
Now, 91 and 92, my lord, initially it was an act granting power to the development authorities. After 74th amendment, this was, my lord, delegated to the concerned municipality, 243 ZF and O. Here, my lord, the delegation was made by under section 111 via departmental circular.
It could not have been made.
So, my lord, the
How DB has treated? DB said it cannot be delegated that
because no, my lord, the matter is sub judice before the division bench.
pending before the division bench. You take notice then. Issue a judgment. Prayer is good. Well drafted. Yeah. The AG is requested to accept notice for
Lord, I am for the operation of one minute.
1. ASC. Ray accepts notice for 1. Emergent notice to 2 and 3. Status quo till next date of hearing. Or
Lord, here, my lord,
any application is filed?
My lord, I.
Lord, here is the unauthorized occupation of the encroach the drainage system and the canal, my lord.
Let us
Without
see. What he says is,
Lordship.
the delegation of power, statutory power, cannot be done by circulars. There is an arguable point. He has read and come back. How can I send him back without any order? Otherwise,
The canal, my lord,
development.
if the water drainage will not be done, my lord, there are the problem
This
is
matter of immediately after service.
Lordship.
Those who come to court with preparation,
Lordship.
how can I send them disappointed? I have to do something for doing things very beautifully. Youngsters are doing so well nowadays. Seniors are not much coming to my court. All youngsters are coming to court.
Here, my lord, point is delegation of essential legislative power
Cannot be delegated.
cannot be delegated.
Tell the maxim in Latin.
I have to see, my lord.
You have to see. I will tell you right now. Delegatus non potestas delegere. All right. I will tell one judgment. Just read it. Pre-Delhi Laws Act.
My lord, 51.
51 Supreme Court.
5 judges,
Correct.
5 judges.
Yeah.
Recently, my lord, GST Council judges.
GST Council.
GST Council judges.
Just look into it. All right. Right now. Heard learned counsel Sri so and so, who argued the matter very passionately and answered all questions of the court very articulately. First off, issued emergent notice. ASC accepts notice for 1. Emergent notice to 2 and 3. First off, the case is made out for granting the interim rebuild, and therefore status quo is directed. Read good books. That helps you. If you read substandard books, you become substandard person. Read best books on administrative law, especially on delegated legislation. There is a whole lot of the jurisprudence by Jain and Jain, Basu, and I.P. Massey, and S.P. Sathe. There are many books, many good books. Just look into them. Vipa Sarathi. Yes. Yes.
Item 13.
Yes, sir.
Petitioner is a retired class 3 employee of Whitpolo University challenging the order of Annex 14, my lord, where the prayer for the religion.
What's that order dated 16/10/20?
That is an Annex 14, page 39.
What is that order? What
The opposite party number 1, 2 rejected the claim of the petitioner not granting TBA, RSCP, MACP as well as the area.
Similar matters we have already admitted. We'll give notice to the other sex.
Yes.
Issue. Or you want a representation? But it is already rejected.
We already rejected.
Issue emergent notice. Utkal University.
Tarananda Patnaik, panel.
See, Patnaik's Learned Panel Council is requested to accept notice for 1 and 2. Yes,
C and
for
4.
3 and 4. 3 and 4. Next.
Item 14.
Page, my lord.
Yes.
My lord, here,
Yes.
my lord, that the arbitrary and illegal order of transfer is under challenge. I am a senior teacher, sir. I am a senior teacher. And I am departing my study there up to standard 8. Now, out of my lord, the political pressure, they have been transferred me to a school where only up to 4th standard students are also reading. Only intentionally to transfer me, not required at all, to transfer me and it deploy me in another school.
Why can't you use some full stops, comma in your statements? In your speech. Why can't you use comma, semicolon, full stop in your speech? Now, political, are you contesting the election?
No, I am not contesting. Although I am a service holder. Sir?
You are only a teacher.
Teacher, sir.
Where is the political influence?
Because the political portions, those are also in the locality, they are also influencing the educational authority to transfer me from one place to another. Because I am an employee, I am interested for transfer. But that should not be degraded me. That I am also studying the student up to standard 8. Now they are also send me to a where the students up to standard 4. That is there.
Your appointment order is for what purpose? Show the appointment order in job chart.
Appointment, sir, the appointment order is that I have to join in the school where the student taking admission or studying up to standard 8.
Up to standard
8, sir.
Yet up to means from first standard to 8.
Yes.
Yes, you are to teach first, second standard also.
That is a degradation because
your appointment itself is for that purpose.
Now, up to standard, I am a senior teacher. I have been declared as senior. Then what the junior teachers will do? Because suppose once I have been declared as a
what
senior.
What is meant by senior teacher? What is the job chart of the senior?
Senior teacher means I put up 15 years service. That is senior. Suppose a person who also put up 2 years, 3 years, 4 years or 5 years in service, they should be treated as a junior. A junior teacher cannot be allowed to teach the student up to standard 8 and a senior teacher will teach the student up to standard 4.
Why can't you import the comma and the full stop from person, gentle lady behind? You import all those things. I'm asking you, kindly be slow.
Sir.
And form sentence.
Sir.
And after completing one sentence, give small space to this guy so that he can assess in the light of his knowledge.
Sir.
I'm asking.
Sorry, sir.
Now, if you are a senior teacher,
yes,
you became senior teacher with effect from which day?
With that in the year, my lord.
Where have you stated?
I am stated as a senior teacher. And
you are saying it to me. Where have you stated with effect from which date you became the senior?
Sir. Sir, para 4, sir. Para 4.
Which date?
The petitioner is a senior teacher discharging his duty as a headmaster in Bhansuri UP Upper Primary School in level 4 grade by departing his teaching to the students up to standard 8.
Yes. Number 1.
Sir, being a center school, the number of students are more than 400 and the experienced teachers are appointed for the center school to like me to teach them for the better future of the people.
Sir, question. The senior teacher shall teach only 8th standard and other higher standard pupils, where is that job chart?
The job chart is not with me right now.
Then get that.
Can
Get it back, so that I can give some.
Sir.
I understand that there should not be, a teacher should not be.
That is the usual practice.
I don't know. I am.
Suppose, sir, only one thing. Suppose this is a center school. More than 400 students or 500 students.
You take notice. Come out, I'll call this matter next week. His grievance is, I could not have been sent to teach the small children.
Yes.
That amounts to degradation, his contention. Let us examine. Suppose if you have appointed a person as a professor emeritus and you send him to the kindergarten, that may be arguably a degradation. Arguable. The degradation, what amounts to degradation? There is whole lot of literature. Therefore, you accept notice. I call this matter next week. Let the meanwhile come back, because students should not suffer. You go on teaching now.
Sir.
I'll call this matter.
Yes.
Issue emergent notice. The GAC is requested to accept notice for all of this. First. Since alleged degradation of rank of the teacher is involved, come on, call this matter next week to have the say of the other side as to interim prayer.
Item 15.
Interim stage.
No.
He has been relieved.
You have to teach. Yes. Next week we will.
Sir, much obliged.
Petitioner to bring job charge.
Yes.
Of senior teacher.
He is a headmaster, sir. He is a headmaster. Discharging as a headmaster now. Being a senior teacher, he has been assigned to duty of a headmaster.
Bring job charge of senior teacher.
Sir.
Next.
Here I was a works contractor. I completed the work. There was some dispute. I raised the arbitration
Case to be disposed of.
Yes. Rahul Shah Millers holds the ground 6
So there is
months.
another judgment which says within 6 months.
You Millers Periamal.
Periamal.
Yes, that also refers to Rahul Shah. The relevant portion, Millers, I'm just giving minutes.
Short grievance of the petitioner is as to the long pendency of his execution case number 104 of 2025. Therefore, he seeks expeditious disposal.
Clause 4.
Thanking on the decision of Apex Board in Periamal.
Periamal, this is Rahul Shah, Periamal and
Rahul Shah.
Para 74. Para 75.
2021.
6 plus Millers 14. Serial.
21 SC 216. Next, having heard the counsel for the petitioner and notice to other side having been taken with in the fitness of things, come on. There is this court find force in the submission of the net counsel for the petitioner that the execution case of defendant has to be expeditiously load out and any within an outer limit of 1 year as held with the Apex Court in Rahul Shah. Next, in those circumstances, the executive court is requested to comply with the mandate of the Apex Court in Rahul Shah Supra and report compliance to the Registrar General of this court. A copy of this order be sent to the office by speed post for information and needful action.
Just the attached file, Millers, attached case is same. Same. 2 decrees had come from the same arbitrator.
Item 16.
Second round litigation, my lord. Second round litigation. My lord, in batch of cases, my lord, this notice and
very good. I should admit this matter. That is strictly translated. Issue emergent notice is requested from the notice for 1 minute emergent notice report. Call along with the briefing number. Your query is very good. Yes.
Item 17.
Both are same.
Both are same.
Next.
Item 17.
Input notice annexed 1 million.
And it is 1
million.
3824. What is that input order present?
The petitioner was working as a Shiksha 1 million.
Guilty of being frequent absent.
Absent.
Why if you are absent, what the student should do?
Due to his illness, my lord. Illness, my lord.
Correct. But what about the fate of the students?
But that's
What they have done now?
No, he is out of service, my lord.
He is disengaged, removed.
This removed, my lord.
What health issue was with you?
My lord.
What was the health issue?
The health issue, my lord, I have given my showcase, enter showcase, my lord. That is, I have written that that I have annexed my enter prescription of the doctors, my lord. I have
What happened?
due to my severe illness, my lord.
Illness means what?
Illness means, my lord, cardiac problem, otherwise, my lord, rheumatism, and due to fainting, that is
Fainting.
fainting due to ill health, my lord, or
Cardiac problem.
my lord, and the rheumatism also.
Huh?
Rheumatism.
Rheumatism. Or romanticism.
That about the house has got fire also.
So many problems God has put in you.
Doctor will advise to avoid alcohol, madam.
Oh,
That is page 61.
alcohol.
Lordship.
Doctor has advised you to lead avoid alcohol. You go to school with alcohol bottle.
No.
Or I haven't consumed it.
No.
With empty bottle.
Mistake communities.
Avoid alcohol. If you are a teacher and consume all alcohol and other things, what the children will have a lesson from you. They also bring
Doctor, I advise to not take an alcohol. Man, that doesn't mean I am taking alcohol.
Doctor will write avoid alcohol.
Well, nobody has a complaint that I am taking alcohol and in the school. Man. That is, doctor has advised not to take alcohol. Due to my ill health. Man.
No. If you are a businessman, if you are a lawyer, if you are a judge, etc., I can understand.
Well,
But many lessons are drawn from the teachers. Our children will be the teachers will define the growth of our children. And if you are an alcohol consumer, how can you be permitted to go to the precincts of the school?
well, I am not taking well, the doctor.
Why doctor will write it's your own document. Unless the doctor says, you will reveal. Why doctor will write like that?
Sometimes the doctor not to take any alcohol. That doesn't mean I am taking the regular alcohol. Man. That is,
You are irregular in taking that.
if I take alcohol, man, that will make an impact. That is.
How many times you have remained absent?
That's 200 some days.
Then what should happen?
Then the lordship and the circular of the government of Odisha, that is annexed to the village committee, education committee, they should have given the report. But the village committee has not given. Lordship and the page 21.
What report? You have remained absent. What should happen to the children in the school?
Due to my health, my issue.
Your health is your problem.
Well,
Assuming that everything is what you say is true. What about the fate of the children? If there is nobody to teach,
there are other teachers.
then you leave and go. Other teachers will look
I am
up.
the Sikha Saga. That is a circular. If I will not work on that, I will unpaid. That
No.
period. I will not get any salary.
Absenteeism in police force, army, teachers. That is not tolerable.
I am not a regular teacher. I am a Sikha Saga. There are other teachers in that school. That is not only one school. One teacher, that is the school will close or the.
A teacher who has been disengaged on the ground of intermittent absence is complaining before the writ court against the termination order dated 13/2024. A copy whereof avails at the next one. But learned counsel for the petitioner vehemently argues that.
Can I pray one thing?
Yes.
So let's say that I have made a reflection before the commissioner come secretary. Let's say taking disposal.
Learned counsel for the petitioner very fairly submits that, regardless of the prayer made in the petition, a representative is sent to the principal secretary. Your representation is longer than our constitution.
Page 9. Page 76.
Where is the date?
Page 76.
76 to 83. Where is the date? On 10th November 2025. And the same is considered in accordance with law. Committee client would be satisfied. Next, Lovely AS
10th number 25 is this honorable court's seal, my lord.
What's still?
My lord.
But when it is given that
We may file.
undated, you put it.
We file a fresh.
Presentation. So, Lovely DSC submits that there is absolutely no evidentiary material to prove the prove that the petitioner has given a representation of the kind. And therefore, if we give one more representation, there would be no difficulty considering the same in accordance with law. First of, with this proposal, counsel for the petitioner is agreed. First of, in the above circumstances, petition is dismissed of document. Next.
Item 18.
In this case, my lord, only on service of a show cause, though I have filed a read for the documents without waiting for or supplying the document. Now the authorities have taken a decision to withdraw my salary and asked thereafter to the sub-collector to comply. And sub-collector has given the complaint that I have not committed any mistake. Later on the receipt. Kindly turn to my lord page 40.
Withdraw the salary means withdraw
the gratinate. Total the salary given to me on a wrong notion.
recovery.
Entire thing is to go. I will not attend to anything. That is the purport.
I'm asking, I want to know.
My lord.
Have they ordered recovery?
No, withdrawn.
Withdrawal of the grant.
Withdrawn. Kindly turn to page 51, man.
You take notice.
And now is because sub-collector has also clarified after receipt of this letter that yes, he has been doing all the duty and now everything is clarified.
You file objections.
Lordship.
I'll give you 2 weeks. Why are we trying unnecessary?
But he having no requisite qualification, my lord.
That is the mistake. No, it has been clarified.
The percentage is less than the requirement, my lord.
That is the mistake. 56.2% I have. They have required 54%. So that is the mistake. That is a collector, sub-collector. There's 58. He has clarified later after this order. Again, he has clarified. He was directed to clarify, not me. Again, kindly turn to page 58.
Where has he clarified?
My lord, kindly turn to page 58, last paragraph, my lord. See, in that particular page, he has said, according to the said advertisement, required minimum qualification mark is eligible for the post was 54%. In this connection, board of interview was held on so-and-so, in which the expert committee stated Rupesh Mahapatra for the post as ascertained from the comparative board seat available at the college, a mention in the resolution dated so-and-so, para so-and-so. Governing body also approved the candidature of Rupesh Mahapatra for the post, which came out successful at the first in the interview dated so-and-so. Accordingly, joined on so-and-so. Thereafter, everything is stated, clarified.
Very clarification.
The
you are having a requisite qualification. Very
that was very good. Everything he has stated that everything we have sent it, and I have 56% that is there on record also. I have secured 56.2%.
They say 54.3%.
Require, and I have the qualification more than that. That is 56.2%. I have stated. My certificate were also there with the authorities at the time of interview. That he has stated. Not in so many words that 56.2. And accordingly, it was also verified in the government level. And I have been paid gratinate since 2014. In 2025, he is issuing a show cause. Before I could have submitted my show cause reply through the governing body, he has directed that we have decided to withdraw your gratinate.
What is the requisite qualification?
Now it was in 54. Again, it became 55. I have 56.2%.
No, prescribed percentage is
at the relevant time when I was selected, it is 54%.
54. We had 54.
56.2. 56.2.
No, that was after the improvement.
Yes, that is after improvement. 56.2%. It was way back in 1993, 2005. I was approved in 2014. Much after that. I had the qualification. That is why it was verified and I was given the benefit.
Issue emergent rupees stay of impugned or till next date of hearing.
Annexure 9 and 14, my lord,
Impugned order.
my lord.
Just
Annexure 9 and 14.
9 and 14.
But that is not the final order, my lord.
Yes, that is the final. 14 is, kindly see, my lord, 14.
Till next
Otherwise,
date.
I would not have come.
Anyway, he has got even otherwise 54.6 he.
Lordship.
56 point,
No, that is improvement.
initial 54.3, yes.
Item 19. May I please, your lordship?
Yes, yes, some of these persons.
May I
All
please, your
this AC for all office?
my lord?
No, government.
Except government.
I have to take emergency.
Except government. Item 19. May I please, your lordship?
Yes.
Petitioner before my lords is a retired captain, my lord. After retirement, he comes from America to Bhubaneswar, my lord. He residing at Bhubaneswar since long, my lord. In his building, my lord, in the outer side of the building, his name is shown as Manas Ranjan Swai, Jyotisha Vastu Kutira.
Refund 10,000.
Yes, my lord. So what happened, my lord, in this case, my lord, on 23rd October, my lord, at 5 p.m., a team came to my house. At that time, I was absent. My wife was present. The team was said to me that why I have fixed your name as a Jyotisha Vastu Kutira. You have to pay 10,000 unless we will lock your house. Immediately, my wife has also paid the 10,000. Only fault from my side, I shown my name and designation as astrologer.
As astrologer.
Yes, my lord.
You have put that board in.
Yes, my lord. This is the only my mistake, my lord. The king was.
If you are astrologer, can't you put the board? Suppose if I he has studied Alan Leo on Western astrology or Varaha Miras Bruhat Jataka, he will put a board saying that I am an astrologer, Oriental astrologer or Occidental astrologer. Where is the requirement of, where is the objection?
That penalty imposed by the BMC, my lord. Bhubaneswar Municipal Corporation.
For putting board, there is any rule?
Take back my take, my lord.
Take notice.
My lord.
Issue emergency notice.
I am so bad, my lord. Peculiar case, my lord.
Yes.
Without anything, my lord.
Emergency notice. And
2 and 3.
2 and
3, my lord. I am for 1.
2 and. Okay.
Item 20. May I please, your lord?
Here, my lord, opposite party number 7 is the headmaster of Nodal UP School, Mangalpur, my lord. He has misappropriated of midday meal and the fund of the school in the name of the student. So the guardian of the student made an application before the collector as well as the block education officer, Gorakhpur.
Who are you?
My lord, I am the guardian of the student.
What is the misconduct?
My lord, regarding the midday meal as well as the fund of the school, the headmaster has misappropriated in the name of the student, my lord. So we made an application before the collector and the block education officer who referred the matter for joint inquiry. That is Annexure 4, page 19, my lord. But
You are a parent.
My lord, parents.
Of which child?
My lord, my child name is Subhendu Behera.
What is the age of the child?
My lord, now age is, my lord, 14, my lord.
14. How you came to know that there is corruption and bribery?
He has been able to leave this school since 31st March 2024.
That is the
This living certificate.
living certificate regarding
School living certificate, my lord.
upper
Yes,
primary. or
Now,
upper-
how you came to know that the teacher is corrupt, bribery, etc.? Who told you?
My lord, my humble submission before Lordship's, my lord, I have mentioned in paragraph 3 that though I am admitted in class 9, my lord, but
Child.
my lord,
Huh.
but now my child name is in class number 6, my lord.
We do not know all that. Your case is not that. Your case is bribery and corruption. Who told you that there is bribery? How you do not go to the school? How you came to know?
But the headmaster of the school has, your lordship is correct, my lord. So, my lord, when I made an application before the collector.
On what basis you made? Your child came and told, my teacher is corrupt. On what basis you got the information that you revealed to me? Otherwise, no teacher will be safe at the hands of hooligans. On what basis you formed opinion that he is corrupt? Where is the link of language, the information? What is? I will impose the cost of ₹1 lakh.
If your lordships, my lord, kindly see Annexure 4, my lord, page 19.
Annexure 4.
My
No, what it is? That B was this one. So the record of joint inquiry by me and so it will be conducted. How he will say that on the basis of your complaint? Tomorrow no teacher will be safe.
That representation is filed by.
You will give representation saying that my parents are corrupted. But where is the information? How you receive the information? You do not go to school.
No, man.
You know. Therefore, somebody should tell it to you from the school. Who told it?
That, my lord, now, how I got the information, my lord.
How? From whom? When?
My lord, when I am studying in class 9, my lord.
You are not studying. Your ward is studying.
Sir, my
What will be studying? In class 9th boy, how he will know bribery and corruption have taken place or not? I am dismissing it with the cost of ₹1 lakh. Because you have to discourage these things.
If your lordships kindly see, my lord, if your lordships kindly see, my that when my student is, my child is studying in class 9, my lord.
That is not
what his name that I have mentioned in.
You have mentioned already, but in paragraph is allegations of corruption, bribery, etc.
No, my lord, that is the midday meal and the
corruption related to MDM rice funds in the above school. How you came to know all these things? You are not part of the school. You are not a member of the managing committee. You are working your field, tilling your land, or doing some butchering work. How you came to know all this? You gave representation, he forms the joint committee. No teacher will be safe tomorrow.
My lord, your lordship is called.
I'll dismiss it with the cost of ₹1 lakh.
My lord, with lordship's permission, my lord, I'm sorry to say, my lord. I'm sorry to say, my lord. I permitted to withdraw, my lord.
No, but everybody will do it tomorrow. Therefore, message has to go to the public. If they play mischief, here is a judge who will haul them up. I will not permit withdrawal. On what basis you formed opinion that the particular teacher is? You are maligning the reputation of a teacher.
My lord, with a lordship's permission, my lord, let me give you one chance, my lord. I will submit the document regarding the corruption, my lord.
How? What document? How you will know? Perhaps you wanted to share the booty. He has not given that booty and therefore you are here. You are not an insider. Only your child goes to the school. Did you ever get into the premises of the school and eat the food? I'll dismiss it with the cost of ₹1 lakh.
My lord, I'm sorry to impose to cost, my lord. Regarding the dismiss.
Otherwise, no teacher will be safe at the hands of the hooligans like your client.
That will be.
You ask your client to tender unconditional apology to the teacher. Then I will permit. Otherwise, I will impose a cost. Matter having been heard, this court was about to dismiss the same with exemplary cost of ₹1 lakh for maligning the reputation of teachers. First off, at this stage, counsel for the petitioner submits that he is trying to offer apology and seek leave of the court to withdraw the petition. First off, whether such apology should be accepted will be decided on the next date of hearing. Call this matter tomorrow.
My lord, day after tomorrow, because
Day
it is not.
But it is all the mischievous fellows. Yes.
Item 21.
May I please your lordship?
Yes.
The present petitioner working as junior clerk is seeking for anticipation of his regulation order, your lordship.
Huh?
In similar matter, your lordship has issued notice yesterday.
Issues. The AG is requested to accept notice for all of these. Yes, call along with WP number.
I'll give the number, your lordship.
Item 22. Item 22.
Chitaluha it is. Mr. Behra.
My lord.
Accept notice, let us.
My lord.
Mr. Behra is requesting to accept notice for notice.
Item 23.
22, my lord.
Yes, notice I have ordered.
My lord, here, my lord, only. My lord, that was occurred in 2012. A list was published indicating all the married persons, including the name of petitioner, my lord. Then thereafter.
Why have you issued notice? Still you want to argue?
No, my lord. I'm not arguing. My lord, what happened, my lord? Direction was given by this honorable court. You engage him upon him because his name was found in the list. Therefore, 20 rules came. 20 rules were challenged. Subsequently,
why all this? Is there any interim relief?
No, because they have already issued engagement over other persons. Those are junior to petitioners.
Have you sought for any interim relief?
No, my lord.
Still you want to argue?
Now, the opposite partner 3 is picking and issuing appointment order to own persons.
Correct. Can I halt it?
No.
Yes, next.
A short that, my lord.
Post immediately after service.
Both are same.
Yes.
Item 23.
Recently, retired headmaster.
Yes.
Retired headmaster inaction of opposite for sanction of pension or pensionary benefit. Similar matter already issue notice made.
Issue emergency notice. PG is requested to accept notice for the OPs. Call along with WP number service. Next.
Item 24.
Connected matter also same.
Yes.
24 my lord, revised scale of pay. Similar matter already issue notice.
Issue emergency notice. AGA for one emergency notice to two. Inverse. Call along with WP number. Yes.
Item 25.
25 matter related to RS Ashok Kumar Mahapatra.
Covered by judgment.
Yes, good.
You got this. Yes, throw down. That sentence you have to mention as representation, etc. Yes.
Item 26.
Item 26, may I please, your lordship? It's an application for implementation of the order passed by the Honorable Tribunal, your lordships. Tribunal has passed an order on 16/12/2015. Operative portion is at page number 16.
What it says?
Honorable Tribunal had directed to bring the petitioner from elementary cadre to secondary cadre. Thereafter,
he has not been brought there.
No, not been brought. Thereafter, state will file and did petition before the challenging that order of dismissed. SLP also dismissed on 23/7/2024.
23/7/24. Mr. Behra, why are you not implementing? Even
My lord,
24. 1 year.
The subsequent development is not.
You accept notice. We call this matter week after next. Yes. In the first week of January, we will call this matter. Yes. PGA is requested to accept notice for all OPs. First off. In short, file for consideration is involved, call this matter in the first week of January 2026.
may I make a prayer, your lordship? The petitioner will be retiring on only 5 months left for a retire.
Yeah, before that it will be over, na?
Yes.
Yeah.
Grateful, lordship. Lordship, fix it.
January.
Yes.
Yes.
Item 27.
May please. In this case, Lord, I am challenging the decision of the government in the Higher Education Department on the Annex 3. Lords may kindly come to page 25.
Fill up vacancy.
By the retired persons, my lord. This is in case of the aided colleges, wherein the government has decided to fill up the regular posts through the retired teachers, my lord.
We have.
Your Lordship is.
Which is that WP?
I will give that. Mr. Lenka is conducting that.
Issue emergency notice. Lenka or your name? They have requested to accept notice for 192 rupees. Call this with WP number.
May I play one thing? I have had a miscase because for stay operation of that.
Next.
My lord.
No steps. Next.
The connected matter is same.
Connected matter?
Same.
Same.
My lord.
Item 28.
28, my lord.
Yeah.
It is a retired person, but not release the gratuity. Annexer 1 is pending, my lord.
Annexer O.
His representation is pending.
Not the grievance of the petitioner is as to non-sanctioning of the gratuity. First, in that connection, petitioner has given a representation dated 22/1/2025 to the Director of Elementary Education, therefore, first, counsel forbids that if the court directs consideration of the said representation, his right would be satisfied. First one. Next one. Mr. Behera appearing for the Behera appearing for the office in all boldness submits that he would instruct the OP number 2 to look into the grievance of the petitioner as has been aired in the subject representation in a time-bound way. If all contentions are kept over. First one. This is official. Next one. Yes, please.
Next is same. Next is same.
also same.
Same. But the retirement date is different, my lord.
So I am not writing any details.
Yes, my lord. The next
Date of representation?
is different, my lord.
Different. That is
Also in Annex 4.
yes.
Item 29.
29, my lord. Similar matter was a grant of SC. After all, Annex 4 is Annex 6 is pending.
You have changed it.
He's changed it. Only prayer may be quoted.
Yes, it will be considered, na? Yeah.
My lord, my prayer may be changed. So
Prayer, you have changed.
Yes,
Put that prayer instead of this.
yes,
Go to that prayer.
yes, ma'am. Problem.
Item 30.
May I please, Your Lord? As the petitioner challenges the transfer order on the recommendation of MPMLA, my lord. Similar matter, my lord, of the same order, my lord. I am handing over that order with necessary correction.
Issue emergent notice. No, same order.
Ma'am.
You have changed dates and other things.
Yes, ma'am.
Same order. Call along with WP number.
My lord, that is also there, ma'am.
That's also there.
That's also there.
Yes.
Item 31.
Please, Your Lordship. But the petitioner is a teacher of an aided educational institution and is receiving granted it after being approved in the year 2004, my lord. My lord, here, my lord, he is getting his salary in the shape of granted aid, my lord.
What is that annexer 9?
Annexer 9, my salary has been withheld, my lord. My granted aid has been withheld without any show cause of the proposed action, my lord.
One is requested to accept notice. What?
But my lord, all the opposite parties except my lord OP4, so all the opposite parties, my lord.
Okay. Next.
My lord, there is an application for interim prayer, my lord.
No, interim order, now we cannot.
My lord, they have
Put
withheld.
this matter week after
My lord,
for consideration of the application.
My lord, I will take 1 minute of your lordship, my lord. They have not issued any show cause of the proposed action, my lord. And it has been issued by the withdrawal order has been issued by the incompetent authority, your lordship. Kindly see.
No, next week, week after next, I am calling this matter.
My lord.
In the meanwhile, let them, in the meanwhile.
My salary has not been released for the last month, my lord.
Sir.
Although I am working, my salary for the last month has not been released, my lord.
Wait, for 2 weeks, just wait.
My lord.
Yes.
Item 32.
Petitioner's application for issuance of marriage certificate is pending before the opposite party number 3, your lordship.
Certificate is to be issued to you.
My lord.
There are certain discrepancies while applying for the marriage certificate. So, but the name is concerned.
Name,
they have not clarified. Date of birth was
only discrepancy why there.
Whether the marriage certificate is registered, marriage is registered or not.
No, ma'am.
Not registered.
My lord, for registering the marriage.
For
registration, they have applied.
My lord, sought for your
To
lordship.
accept notice, Mr. Mohanty, just
Your
ask.
lordship, my application is pending, your lordship, direct to consider in accordance with law.
Representation.
Annexed, your lordship.
Fourth series.
Annexed 3 series, 4 series, your lordship, 4 series.
No, application has been rejected.
My lord, later I have
sent Aadhaar card.
my lord, after rejection, I have submitted all the document with corrected document, your lordship.
Where are they?
My lord,
Page
your lordship,
17,
kind
page
of page 17, in page 17, date of birth of the petitioner in the school living certificate and Aadhaar card are different. Therefore, my application was rejected, your
Short
lordship.
grievance of the petitioner, regardless of prayer column, is as to non-registration of the marriage. First one. The counsel for the petitioner submits that although the application was earlier rejected for want of necessary information and also because of certain defects in the application, the same having been made good, another application has been filed on
your lordship, 21/7/2025.
21/7/2025, and therefore OP number
3, your lordship.
3 may be directed to register the marriage. First one. Learned AGA Mr. Mohanty, in all fairness, submits that he would instruct OP number
3.
3 years.
to look into the grievance of the petitioner by having grievance of the petitioner as has been aired in the subject application. First off, he assures that if all compliances are done, there would be no difficulty for effecting registration of the marriage of the petitioner. With that, with whom?
Both have applied.
With the of the petitioners. First, this is appreciable. Next one. In the above circumstances, petition is disposed of to take a call on the subject application within a period of 4 weeks, subject to all compliances being made by the petitioner. In accordance with law, within 4 weeks, subject to circumstances. Okay.
Item 33.
May I please, your lordship, my lord, I am in BCML. I am in BC, my lord. The petitioner challenges, my lord, due to the non-acceptance of the property statement, her promotion has been decided to withhold, my lord. The GA department, Annex 4, page 18, stated that further the deadline cannot be extended. My lord, the property statement is to be submitted through HRMS portal, my lord, with the due date. That is, my lord, due to the technical problem, my lord, it was the HRMS portal could not be open and he could not file, my lord. And the offline, they are not accepting, my lord. Identical issue, your lordship may see, Annex 5, page 19, has already decided by this honorable court, my lord. And page 23, your lordship may see.
This is non-submission of the property list for the purpose of promotion. So their allegation is because of this failure in
and even when we wanted to upload, it did not accept.
So that is in page 23, my lord, similar coordinate bench order.
Same order we can make.
My lord, to provide, because my lord, that is a statutory right promotion, my lord, and your lordship is directed that either open or accept the offline. I am ready to submit the property statement, my lord. But there, the HRMS portal is not opening and they are not accepting the on offline, my lord.
Petition. That's it. First, learned counsel for the petitioner submits, and the learned AGA Mr. Mohanty does not much dispute that the subject matter of the petition is substantially covered by the coordinate bench decision. In WPC 42417 of 2023 between Ashish Kumar Bhadra versus State of Odisha. Disposed of on 2/1/2024. First. Next paragraph. In the operative portion of the order, at para 6, the following observation occurs. Next paragraph. In the above circumstances, this petition is put out, granting same relief as has been recorded with coordinate in the cognate case. But that is this.
Item 34.
34, my lord, WPC number 32946 of 2025, Hiroti Tanaya Sao, my lord, kindly permitted to withdraw within liberty to file a better application. 32946. There is some mistake on my part, therefore, permitted to withdraw within liberty. Last book is what? Hiroti Tanaya Sao.
WP?
32946.
32946.
In other part, my lord, the petitioner challenged the advertisement issued by the DD University Keonjhar for engagement of assistant professor guest faculty in different departments in the medias of the academic session. My lord was already passed a similar order in other cases.
These are the matters regarding guest faculty lecturer.
In the midst of the year, they have listeners without reflecting anything in the advertisement that how many posts they have declared for the advertisement and in which academic sessions that advertisement has been issued.
The subject matter of this petition is similar to the one in WPC 31883 of 2025, wherein interim relief has been granted, directing continuation of the petitioners in service pendent delete. First. However, the process in terms of the impugned employment notice has not been halted. First, learned counsel for the petitioner submits that the same relief needs to be, same interim protection needs to be extended to his clients, since they are similarly circumstanced. There is force in this submission. Next, in the above circumstances, issue emergency notice. First of Mr. Mohanty Laledi accepts notice for the OP number 1. Who appears for 2?
Who their panel of, because this is autonomous.
To OP number 2. Interim order as in WP 31883 of 2025. All this matter along with 31883. All these matters common. Yes.
Item 35.
Kindly pass over.
Yes.
Item 36.
Kindly pass over to after lunch.
Pass.
Item 37.
May I plead, my lord? Therefore, the petitioner, my lord. My lord, we are pleading for the IA number 19259. That is for the direction of OP number 2 and 3 for stay of fresh auction of the scheduled plot of land and stay of
matter.
My lord, the matter is the railway had leased a plot of land to the father of the petitioner for a shop, opening a shop. And then after the father died, the petitioner's elder brother applied as a legal heir for the transfer of that lease. Then before the lease,
What is difference between legal heir and legal representative?
legal heirs, my lord, legal heirs are as per the certificate, legal heir certificate, who are to succeed the death after the person dies, or they are to be held responsible for successors.
They are legal representative.
Yeah.
All legal heirs need not be legal representatives. All legal representatives may not be legal heirs also. CPC defines legal heir, legal representative. There are some issues. Just looking.
Yes.
Anyway.
So before the execution of transfer of that lease land, the elder brother also died. Now the petitioner is the only legal heir and legal representative of the main leaseholder and the elder brother, and she is the only earning person in the family also. Now she had applied for the transfer of the lease land in her name.
She is sister.
She is the sister, widowed sister.
Widowed sister.
Yes. She had applied, but they rejected it on the ground that they had the railway had once had a provision to transfer the lease only once. But as per the documents, if we go into the merit of the writ petition, the final execution of the writ of the lease in the name of the elder brother had not been executed. But that is a different issue, or in the merit of the case.
There is no transfer at all.
My lord?
There is no transfer as such.
No, my lord. The final execution was still
because he died.
Before he, and that. So after that.
What do you say?
So we have prepared the computer. This case, and I saw the copy of it. In this case, the father of the petitioner.
No, you have prepared counter and you have kept it in your pocket. Have you filed it?
No, ma'am.
You have kept it in your pocket. But how I can put my hand into your pocket?
But today I'll serve and I'll finally file.
Okay. First week of January 2026. At the request of the network page for the railway. Who wants to fight the counter in the meanwhile? First, if counter is not filed, petition ever should be taken with face value. May be taken with face value. Yes, next.
My lord, interim protection may be cut.
Is there already? Interim order is there?
Yes, my lord.
Interim order continues. Then second week of.
Oblige, my lord.
You argued well. Yes, now you have to sit and show which is the section in CPC, legal heir, legal representative, etc.
Yes, ma'am. I am sitting here.
Give him CPC. Take that and return also.
Yes.
And just take away home.
No person.
Yeah. There is one Sanskrit shloka. Pustaka vanita vittam parahaste gatam gatam. The books and money, if they are given, they will go.
Nowadays,
also, I'm not saying anything.
Nowadays, camera is there, no one can take everything.
Yes.
Item 38.
38.
Yes, my lord.
Yes.
38 and 39. Your lordship may kindly see in 39, 9 cases are there. All are similar. Your lordship has decided. I have served a copy to my lord.
Covered by judgment.
Covered by your lordship judgment. Only this will be changed.
Given the kind indulgence, because of that completion of that scheme, subsequently my lord has directed, if at all possible, that may consider. Likewise, my lord has passed this judgment also.
Give that.
My lord may kindly see with 2 copies. Even if in one case they filed counter after 11 years, your lordship import cost per year 2,000.
Here my
cost. 2 judgments I have brought.
It is page 8, my lord.
They have what?
Page 8.
Page 8, 7.6.
7.6.
All were engaged. Thereafter, working for some time, they were engaged. They did not allow us to enter in the new scheme.
For that, your lordship said why this is stepmotherly attitude.
Subject matter of these petitions is substantially similar to the one in WP. Which one I should refer?
My lord, both your lordship may refer. Because both are your lordship may refer.
39.
16773 of 2016. Jugal Chandra Naik. That will be, because that is a very good judgment. Your lordship has dealt, my lord, ornamental language.
73 of 2016 with the WPC 16774 of 2016 between Jugal Charan Nayak and another versus State of Odisha and others, heard and disposed of by this court wide order dated 2025. First one. At paragraph
7.6.
7.4 to 7.6.
Yes.
The following observations appear. Next paragraph. Learned counsel for the petitioner said, he writing telling that like cases should be treated alike, and where the relief has been granted to a set of litigants, the same cannot be denied to the other set, which is similarly circumstanced. The operative portion of the order in the cognate case incorporates a writ of mandamus to the whoopies to absorb petitioners in any new scheme or project within 8 weeks without driving them to one more round of legal battle.
Only that education part, it may be there, because they don't have the qualification. So, and how you appointed us without qualification? Initially, while it is a scheme for universalization of the elementary education.
But that contention is considered.
Yes.
At para 7.4. Therefore, I have reproduced everything.
That education will be taken into consideration while. How that will create another litigation. Because in the meantime, they have. Your lordship indicated this is third round of litigation. Even if earlier judgment. My contention, my submission.
Whatever educational qualifications have been prescribed, may not now come in the way, since the petitioners are old hats.
Yes, ma'am.
Old hats. First one. Next one. Ordered accordingly, and writ petitions are disposed of. In terms of the cognitive.
Right? Only all the petitioners' engagement and disengagement are different. That's
yes. Understood. This is 33 and 34. 33 and 34.
38 and 39. 38 and 39. 38 and 39. Bunch of cases are there, 39. 38 are also similar to 39.
Yes. Can I come back within 2 minutes, 3 minutes?
Fine. That Passover matter. My learned friend is there.
Yes.
Well, this matter relates to grant of senior scale of pay. I was favored with senior lecturer scale.
It's a post notice.
Post notice matter.
Are you ready in the matter?
No, but you have to file the counter because Annex 10 is the impugned order.
They say that writ appeal is pending. That is the only ground. But my case is squarely covered by the judgment of this honorable.
The judgment who is relying upon
Writ appeal.
Yes, that
Will
is
dispose
pending.
of this petition.
Yes.
Subject to outcome of the appeal.
Yes.
Whatever happens to the appeal will happen to him also.
Yes.
Over.
And there is no.
Or else outing that appeal.
Anyway, I will not be in any way prejudiced. This matter is covered by that judgment. This matter is in appeal. Therefore, the relief granted to the petitioner is subject to outcome of the appeal.
Yes.
That number will reflect.
Any stay is granted there.
No interim order. But I have brought the
1564 of 2024.
Yeah.
Your Lordship may kindly see the impugned order at page 49.
Petition prayer reads as under. Learned counsel for the petitioner submit that the subject matter of this petition is substantially similar to the one in WPC 14451 of 2016 between Sanjeev Kumar Mohanty versus State of Orissa and others, heard and disposed of by a coordinate bench of this court, wide order dated 7/2/2024. No, 6/3/2024. 24. Whereby at paragraph 9.5.
Yes.
Impugned order of the kind having been quashed.
Yes.
Relief has been accorded. First up. The said paragraph reads as under. Next paragraph. Paragraph 9.5, being the operative portion of the judgment, is reproduced for ease of reference. First up. Below that, no paragraph. Learned AGA Mr. Mohanty submits that the subject judgment, the said judgment has been put in appeal, put in challenge in writ appeal number
1564 of 2024.
And therefore, till the disposal of the said writ appeal, this matter may not be disposed of. This matter may be kept pending. When asked as to whether there is any interim order of stay, in all fairness, Mr. Mohanty submits, to his knowledge, there is no such thing. First one. Next paragraph. Learned counsel for the petitioner, on being asked, specifically tells the court that there is no interim order.
There is no interim
in the pending appeal, which may take its own time to come up for final disposal. First, he also tells that let the relief be granted to his client, subject to outcome of the writ. First, this is fair and reasonable. Next paragraph. In the above circumstances, this writ petition succeeds. Impugned order
Annexure 10.
At Annexure 10 is quashed by issuance of writ of certiorari. First up, the writ of mandamus issues as has been issued in the cognate petition. Yes. Cognate petition. Subject to cognate petition. First, all this is subject to outcome of the writ. Yes.
May I please tell us? We have filed the complaint affidavit that is not in Lordship's board, my lord.
You want to file a counter?
We have filed the compliance affidavit.
Compliance affidavit you have filed. Is it complaint?
No, my lord.
And what is the order?
My lord, your lordship's order, your lordship may kindly see, order dated 27/10/25.
No, 13/3/2019. Go to 13/3/29.
Yes, my lord. 13/3. Thereafter, my lord, 28/3/19.
13/3. Where is the order? 13/3.
13/3, your lordship may kindly see. I will read out, my lord, this order. Yes, ma'am. My lord, the part further content. This contempt petition has been filed against non-compliance of the order dated 21/1/19 passed by this court in WPC number 643 of 19, my lord. Mr. P.K. Mohanty, learned counsel for the petitioner, contended that this court while dispose of the WPC number 643 of 2019 filed order dated 21/1/2019 passed the following order. No construction work on plot number 167 under Khata number 266 in Mujal.
Order.
My lord, this order has been violated. The interim order has been violated. In spite of this order, my lord, construction work continued, and also this is the public road, my lord. The petitioner is unable to come out of her house, and your lordship may kindly consider, my lord, in spite of this order, in spite of the communication of this order to the collector, my lord.
Wait, Mr. Lordship.
Your lordship may kindly see the photograph I have brought, my lord.
I'm asking him.
Yes. Sorry.
He said, despite the interim order, construction went on. How? Why?
But the pursuant to my lord's order, the collector has passed the final order, lordship. Saying that I'm placing, my lord, the irrelevant portion, my lord.
Collector of which district?
My lord, the Balasore district, my lord. He has directed to consider the petitioner's representation. Lordship, I am very placing the order, my lord, the operative part, my lord. No construction work on plot number 167 under Khata number 266 in Mauja, Mundobonia shall be taken up till disposal of the aforesaid representation of the petitioner by the collector Balasore, opposite part number 1. Therefore, the petitioner is not able to come out from her house. Though this fact has been brought to the notice of the local police, they have not taken care of the issue. Rather, they told that unless the order of the collector Balasore, no action can be taken. Decision so taken on the representation shall be communicated to the petitioner.
What was now the compliances of interim order?
Yes, my lord. Compliance of the
final order, my lord.
Final order.
Yes, my lord. Compliance of the interim order, my lord.
Interim order. Final order is made in this case, no?
No, my lord.
No final order.
No, my lord. Your lordship may kindly see the counter up.
I want to understand. Yes, you have to make the judge understand. If you want an order at his hand.
Yes, madam.
Now, this writ petition is still pending.
No. This writ petition disposed of.
What was the order?
Yes, my lord, 21/1. Your lordship may kindly see. The order dated
by other judge?
Yes, madam. 21/1/2019, my lord.
Still disposal of. They are saying still disposal of your representation.
No construction work on plot number so and so shall be taken up in the meantime, my lord. While before disposal of the representation, the construction work continued. Therefore, this contempt petition was filed. And also in the contempt petition, several directions has been issued. Your lordship's order, your lordship may kindly see last order.
But now matter itself is this. Main matter itself is this sort of.
Main matter, my lord. Now your lordship's order, my lord, 1410, that is 13/10/2025. In this order, your lordship was pleased to direct the state council to come out with a report on the next date of hearing with regard to the present ground position of the situation, my lord. My lord, thereafter your lordship has directed to comply the order dated 28/3/19 and also 13/3/19. My lord.
But that interim order not to put up construction.
Yes, ma'am.
Was during the pendency of your application.
Representation. Yes, ma'am.
Now representation is disposed of when?
Till today, representation has not been disposed of.
No, it is
Disposed of, my lord.
No.
when it is disposed.
Annexure V, my lord, lordship kindly.
Annexure?
No, it is not my lord's. Yeah, then
Your objection.
lordship, the compliance affidavit, my lord. It's
In compliance of it. You get.
not in lordship's board, my lord. There.
Filed yesterday. You have filed yesterday. It has not come. Ask them to send. Do you have that complaint support?
Yes,
They have given to you?
Yes, ma'am.
Yes, ma'am.
You pass on the file.
Yes.
Why it has not come? Yesterday they have.
While the collector is hearing the contempt petition, this order has been passed in the contempt petition. Paragraph 7, your lordship may kindly see, pursuant to your lordship's order, he has passed this order. My representation has not been disposed of till today.
Disposed of 14/11/2025.
See, now you are entitled to make use of plot number 168.
168?
Darbari.
Well, that is 168 is the ancestral property. 11 share only 4 decimal, my lord. That is disputed. That therefore the public, admittedly, this is a public road, my lord. On the
Public road, a public building is constructed.
Yes, my lord.
Yes.
When this building was about to be constructed, my lord, at that time the petitioner approved this honorable court. And this honorable court was pleased to pass the.
You have said all that. No?
Yes, my lord. In spite of the order of this order, the order of this honorable court has been violated, my lord.
No, they have disposed of your representation also.
Well, your lordship may kindly see the photograph. They are unable to come.
No, that question is, you should file suit for that. We cannot decide all these disputed facts in the petition.
No, my lord, I am not going to that. My lord, whether the order of this honorable court has been violated or not.
They say it is not violated because structure has been put in the year 2019.
2019, my lord, this petitioner approved this honorable court and also filed the contempt petition when the violating this order of this honorable court and the construction work was issued. My lord, I am showing the from my so-called the compliance affidavit.
Anyway, the construction is not on your property.
It's not on the road, my lord. On the road, I am using that road from my house, my lord, from going and coming from my house, my lord. That is no other road, my lord.
There is now there is another property beside you. So it's our plot number 162. Petitioner is using plot number 162. Kisam Sarad.
That is agricultural.
My lord, that is my house. Where my house stands, my lord.
That is agricultural land, my lord. But he has to approach for conversion, my lord. Only the road cannot be converted, my lord. to homestead, my lord.
Well, maybe my house is standing there. I am, as per law, the Tahsildar may take action against me. I have constructed the house on the agricultural land. But how I will come out from my house, my lord?
Where are you now? Inside the house, all the 6 years?
You lost me kindly. See the map I am giving. Only 2.5 feet, that is the setback left by the construction of the community center, my lord, through which I am coming.
Correct. You mean to say that we should pull down the center now?
My lord?
You mean to say we should pull down the construction? It's built on the public road with public money. At the most, we can say why you should let we'll call notice and everything will be. But question is ultimately, can we pull down the building which is meant for public at large?
Well, in spite of the direction of the Honorable Court, this building was made. And also, you will kindly see, in this case,
So are you saying that building should be pulled down?
Yes, my lord, they have stated so. You will pass over my compliance affidavit, I will show. My lord, in the paragraph,
You work out remedy at the moment.
Yes, my lord, I am coming to that, my lord. My lord, in paragraph 6 it has been stated, my lord, it is further submitted that one appeal case filed by Hatim Shah and others of village Mundabania, Bogarei, bearing appeal number so and so against the LE case number 263 of 19, which is filed before the sub-collector Baleswar, which pertains to the same parcel of land and is directly connected to the subject matter of the present contempt petition. The said appeal has since been dismissed due to non-appearance of the applicant. Well, in this case, the Tahsildar has initiated a encroachment proceeding against the villagers and also the OP number 4 who has been implicated in my writ petition for unauthorized construction over the land in question, which is a public road, my lord. Encroachment proceeding was initiated. In the encroachment proceeding, encroachment order was issued. Thereafter, challenging that order, the villagers have approached the sub-collector. Sub-collector has dismissed that got dismissed before the sub-collector. Therefore, the order of Tahsildar in encroachment proceeding for eviction and demolition has got its finality. Therefore, they have admitted that is a public road, and also I am coming through that road, and also on the said road the construction has been made in contravention of the OPL Act, and OPL proceeding culminated holding that this construction is unauthorized, and order has been passed. Therefore, even if it is stated by the Tahsildar and also the collector has stipulated in its compliance affidavit, my lord, how the compliance has been made? Interim order has been violated. Order of eviction and demolition has been passed. Appeal has been dismissed. Still then, my lord, there also, and also I have shown the photograph, only setback. Setback is left for ingress and egress of air from the house, not for the foot passengers. How they will come, my lord?
You file a suit. I will permit you. All disputed questions are involved. All these things we cannot decide. Though there was an order not to put up construction. Your allegation is that the construction has been done in violation of that order of 2019. All that how can I decide in these matters? Now, you file a suit.
My lord, you I am showing another document. You will kindly see, when this matter came up for hearing, it was submitted to the court that we have received instruction. We are taking steps to remove the unauthorized construction, my lord.
It is unauthorized construction?
Yes, my lord.
Why?
Well, on the public road, my lord.
No, public road belongs to the government.
Yes, my lord. Yes, my lord. I am using that
to hear the judge also.
My lord, how the money was sanctioned for to construct a community center, and how your lordship may tell us how your lordship may send one person, how the community center is used. The community center is deserted and left, and also the hens and dogs are stored there, and there is no window fittings, nothing. Only the nearby residents are using that.
You get a videograph of entire that area, including the building. What for you are using, what is the stage of the building, whether really community.
Yes, ma'am.
You give full report along with whole videograph of the topography.
I have given this photograph. You must make a list.
That will not be sufficient.
Yes, ma'am. Please.
Counsel for the petitioner submits that there is a building that has been put up in cross violation of certain orders passed by this court, and therefore action should be taken for violating the said order, and also to remedial measures by pulling down the buildings unauthorizedly constructed on the public road. First off, he also tells that in view of this construction, his ingress and egress to his own house is materially prejudiced. First off. Next one. Learned ASC has filed the compliance report stating that the construction in question was effected long before the interim orders were passed, and that many disputed facts are involved in the case, and therefore petitioner is relegated to the civil court. First time. Next paragraph. To consider the rival contentions, it is necessary that all facts are before this court. First time. The facts can be ascertained by obtaining a complete videograph of the area in question in general, and the building said to have been constructed on the public road abutting petitioner's property. Complainant's property.
Yes,
complainant property. First, the who will do that?
The district local Tahsildar.
The local Tahsildar, the jurisdiction Tahsildar shall accomplish this task and file the report on the next date of hearing. First, it is open to the petitioner to be present at the spot after having a discussion with the Tahsildar as to date and time. First, call this matter in first week of January 2026.
Pray one thing, my lord. The lordship may kindly direct the state councils to produce the encroachment case number 263 of 2019. Everything is there, my lord. Encroachment case, my lord. That has been.
You just keep that.
Yes, my lord.
The DSC shall keep the case file of case number.
LE case number 263 of 2019.
Okay. For ready reference on the next date of hearing. Okay.
Item 41.
Yes.
Item 41. Pardon, my lord. I have returned the CPC, my lord, and I have referred for that legal hair and legal representative part you had given.
What it says?
My lord, the clear understanding. My lord, the clear understanding. The under section 211, the legal representative has been defined, and a person who in law represents the estate of a deceased person, and includes any person who intermeddles with the estate of the deceased, and where a party sues or is sued in a representative character, the person on whom the estate devolves on the death of the party so being suing or sued.
So, for a legal representative, there must be proper estate.
Yes,
Unless there is a estate, There is no question of legal representation and so on. For legal aid, it need not be. Is it defined then?
The legal aid is
defined?
legal aid is defined in Succession Act, and the point of distinction is interstate, where the legal heirs can succeed even when there is no will, only when there is no will, and the succession happens interstate.
And testament.
Yes.
Thank you.
Thank you very much.
Well,
Lordship, in item 41, my senior is supposed to argue this matter. But there is a bereavement in his family.
Second week of January 2022. On the meanwhile, I will file in the family of RB counsel for the petition. In the meanwhile, I will file counter. In the meanwhile, counter, if any, may be filed after serving a copy thereof.
Not order to continue. Interim orders to continue.
Interim orders to continue. Till next year. Yes.
Item 42.
42, my lord, I may be permitted to file counter, my lord.
You want to file counter after 3 years?
My lord, at 1 week, only 1 week can bring.
3 weeks granted for filing counter. Subject to payment of cost of rupees 5,000 to the other side.
That in the book for him.
5 and 6. 5 and 6.
5.6.
Yes, my lord.
5.6. In 5.6.
5 and 6, my lord.
5 and 6. You pay 5,000 rupees to OP numbers 5 and 6. Correct? The payment to be made by to whom?
My lord, I am for the petitioner.
Petitioner.
My lord.
You are a peer for 5 and 6.
Yes, my lord.
OP number 5 and 6 to pay collectively a sum of rupees 5,000 to the petitioner as a precondition for filing of the counter. Since counter has not been filed for more than 3 years. Okay.
My lord, fixed date after 3 weeks.
Yes.
Fixed date.
In the second week of January 2026. Okay.
Item 43.
Small grievance of the petitioner is that the petitioner, while working under the opposite part number 4, a vigilance case has been initiated against the 4 persons. Some regarding some misappropriation.
Ready in the matter?
This is a small matter, sir.
Vigilance.
Sir,
panel councils.
sir, just
vigilance.
no, only sir.
Whether he is ready or not, we have to ascertain. Otherwise, he will argue for half an hour and he says,
only 2 minutes, my lord. Only. What is the matter? On the basing on the vigilance case, on arrest, he approached this honorable court through an anticipatory bail. Under Annex 2, my lord, page 18 is very vital. This honorable court directed to grant anticipatory bail with a condition to deposit 5 lakhs before the opposite part number 4. The petitioner, on the basis of the direction of this honorable court, has deposited 5 lakhs before opposite part number 4. Subsequently, the vigilance opposite part number 3 has exonerated the petitioner. Exonerated the petitioner. Annex 4, page 20.
So, the petitioner. Acquittal or exoneration?
No substance has been found in this case, my lord. He has, out of 4 persons, he said that.
Was it before the criminal court?
Yes, my lord. Vigilance case, Bhubaneswar.
Criminal court.
Criminal.
But you are using the word exoneration. Exoneration is unknown to criminal law.
No,
either discharge, acquittal.
No charge sheet has been filed, so proved against.
Discharge.
My lord. Charge sheet has been submitted against Manoj Kumar Pandey only to face the trial in the court of law. Allegation against the other accused persons could not be substantiated.
They are not set up for trial at all.
No, my lord. No charge sheet. So he made a representation before the opposite part number 4 to release my the 5 lakhs because on the condition that that is the only things.
My lord, open number 4 did not appear, my lord. And so far the vigilance department is concerned, the standing counsel, Mr. Sangram Das, he has already appeared.
A small matter only.
Yes, but you want to.
But the small advocate has to come and ask. But why are you retaining that money? He was granted anticipatory bail subject to condition that he should remit the money. He has remitted. No, he has not been set up for trial at all. No charge sheet having been filed. That money has to be returned to him.
The money is deposited with the market, my lord.
With the
Opposite partner 4.
Bring your friend next week.
Market has not appeared.
The board is appearing in spite of notice since 2023, sir.
He is not appearing.
He is not appearing.
No, it is appearing.
Why? Send us.
AD back
Just
for valid service.
Get the phone number of the council. You give phone number. Our registry will call him by phone now. All right.
4 is not appearing. Vigilance standing council. Vigilance standing council is appeared, my lord. But the OP number 4.
OP number 4 to we give the money, sir.
You have to bring the lawyer. Otherwise, how we can solve this matter?
Sir, pass over through, sir. I am trying my best.
Yes, go ahead.
Pass over.
Pass over.
Item 44. 44, my file has been misplaced. I refer for that. My file has been misplaced. I refer for that.
Misplaced. Last registry to give copy of the
very reluctantly time was granted last time. 72 years deprived of promotion.
One more chance. Registry to give a copy of E-file to the learned ASC who believes that the file is misplaced and not be traced. First, call this matter after 2 weeks. Yes.
Next week, any date?
Next week, we have many matters I have already.
Any date, a week after also, I have not. Any date may be fixed so that it come.
17th. Yes.
Item 45. 70.
December. Yeah. 45. Yes.
45, my lords. Mr. Mukherjee mentioned and your lordship told to come at 2 p.m.
2 p.m. Yes.
Item 46.
Shipping item 46. It is a lordship revised my pay scale, your lordship.
46, my lords. The counter is ready. You will file within a week, my lord.
2 weeks for filing.
Lordship, there is a judgment, your lordship. Cover matter, your lordship.
Covered by the
Lordship.
but the counter is ready, he is saying. Is it covered by the judgment?
My lord, I have the judgment, lordship.
Just if you show, you have to show it to him. He should say.
Lordship, my pay scale was revised from the year 2000. Lordship, I have given.
But my lords, I will verify. Let it come.
Next week, let it.
Lordship, my fixed one date. Lordship, I have. Lordship, my fixed one date. Lordship.
Yes. Next.
Item 47.
Next.
Yeah.
Date is going to be taken up along with item 51 because they belong to the same department.
Both are same.
Yes, my lord. Utkal University and MBA PG department.
In the second week of January.
My lord, today it is listed 51.
Yeah. But Patnaik, I have issued notice in some matter. Just correct the 40 and 51.
51. My lord, may I please?
Next week or any day?
No, today it is there, my lord. I
Okay. Yes, for this matter on the 18th.
18th.
Next.
18th.
Call along with the 50.
51.
51.
8/9 of 2002.
Okay.
My lord,
Yes.
18th December, my lord.
Yes.
Great.
Item 48.
48.
I am for the opposite party. My lord, I am praying for 1 week time, my lord. I seek permission from your lordship to file an additional affidavit.
2 weeks granted.
Lordship,
For
can I-
filing provisional affidavit at the request of the Yes.
Your Lordship, on behalf of the petitioner, can I pray for a date in next week because already adjournment?
Second week of January. Not
Your
now.
Lordship,
Yes.
Your Lordship, interim order to continue.
Interim order to continue. Yes.
Item 49.
Oh, corridor. He has some personal problems.
Item 49.
Sir. My lord, I am appearing on behalf of SN Patnaik for OP3. Staff selection commission.
OP3.
I have filed a counter, copy of rejoinder to.
Rejoinder, I will find any rejoinder.
Yes, my lord.
Then give copy to him.
It is solved. Solved, my lord. Sir, it is solved. Patnaik sir has received it.
Patnaik has received it.
Yes.
You are not given to him. To give one copy.
My lord. This is covered case, my lord.
Covered by judgment?
Yes, my lord.
With judgment?
Yes, my lord.
Where is your opponents? Where are your opponents?
My lord.
This matter went in appeal to the division bench?
No, my lord.
No. But which covered by which judgment? The division bench judgment?
Single bench and double bench. Coordinate.
Both.
Yes.
What is the issue?
My lord, it is regarding appointment of Hindi teacher in secondary school, my lord. The candidate has secured more than the cutoff mark. She was allowed to appear in the recruitment process and she got the mark, my lord, which is more than the cutoff mark. But she was denied her appointment on the point that she has not secured the required mark in graduation level.
The single judge's order was in appeal before the division bench.
Yes, my lord.
Because that is mentioned here.
My lord, many cases has been filed and it has been decided, my lord. So in Aparna Sinha case, my lord, Supreme Court has also decided this matter and it has come to finality, my lord.
My lord.
She has got the requisite qualification, my lord, but they are denying it arbitrarily and she has not been given the appointment since 2 years. She has got every right for appointment.
How many marks she has secured?
120 point.
It cannot be like that.
120.5, my lord.
120.5.
120.5. Cutoff mark is 119, my lord.
119?
At page 47, my lord. Page 47, 120.5. Cutoff mark is 119 at page 51, my lord.
Hindi teacher?
Yes, my lord. It is of the year 2022, my lord. She has not been given the appointment, though she has got every eligibility and deserved for appointment, my lord.
Yes, brother. The single judge's order covers his case and that has been affirmed by the division bench of Honorable Chief Justice.
My lord, Aparna Sinha, another case is there, my lord. Aparna Sinha case that also covered, which has attended finality. My lord, they are disputing about the Rashtrabhasha Ratna qualification.
That they cannot do.
Which is equivalent to graduation. Government of India has considered this.
But who is your true opponent?
My lord, Director Secondary Education.
Director Secondary Education. Mr.
My lord. My lord,
just look into that judgment.
My lords, this is counter.
Justice BP Satpathy.
My lord.
That order has been affirmed by the division bench now.
My lords, let him supply.
You come. Mr. Bever also.
My lord, Rashtrabhasha Ratna in the resolution, my lord. My lord. You copy. Yes, copy. Yes, sir.
So that we'll have it next week.
Sir. Sir, equivalency is there, my lord. Resolution, the equivalency.
Unless one sees the order, you will not be able to tell, na?
My lord.
You give one set of copies to them, judgment copies.
On Monday, my lord, I pray for Monday.
Monday we have difficulty wait.
Next Monday, my lord.
next Thursday.
My lord, I will come from Bolangir, my lord, covering 350 kilometers.
Coming from India.
Yes.
But even on Monday, you have to come that way.
My lord, I take one rest before appearing.
My lords, may I pray we capture, my lords, because it is the counter is ready. It will be filed.
Counter is filed on which date?
Not filed.
No, which date it is prepared?
My lord, counter and
within a week. Within a week, I will file. Within a week.
Fine.
My lord,
Anyway, matter is covered. Have you referred to that judgment?
He has not given. I will verify and I will file.
My lord, OSSC, who is the recruiting body, my lord.
Anyway,
They have filed the counter, my lord. They have filed counter and rejoinder is there, my lord.
27.
My lord. Okay.
Yes.
Item 15. May I preview one? Can we see order different last order 28/10/2025. After 15 years selected pursuant to a selection, I faced termination. That's why your lordship wanted how many vacancies are there?
This matter has been alerted to my learned friend G. Milon.
G has not come today.
Morning, she has felt certain problem in the eyesight. Immediately rushed for medical checkup. May I pray for the same kindly accommodate
all this matter on 27th. 27th. Let me see. Yes.
Item 51 has been adjourned. Item 52.
Second litigation challenging the rejection order for grant of a third MSc. Matter is not. Yeah.
How many years?
30 years, man.
30 years.
Yes. Government has not filed.
What do you say?
He has to file the counter also. This has all the way. This has been alerted from 50 to 57. But however, I am.
Counter to file.
How many times the litigant should come to the court? Any objections are filed? Kumar Mahapatra.
Yes, madam.
Ready to 52. 52.
Where are the equivalence of service conditions? Mahapatra conditions, what were those conditions? What are your conditions?
The Mahapatra condition, my lord. Ashok Kumar Mahapatra was the reduction of percentage. Both they are the school or employee prior to taking over high school, my lord.
Huh?
My lord, page number 11.
Is 11?
Yes, my lord. So, issue of for the court, the Ashok Kumar Mahapatra case, whether the deduction of 50% service or taken over, high school employee prior to taken over, pre-taken over.
What is this matter about? That is before taking over, whatever service has been rendered, whether it should be counted or not, is the issue.
Yes, ma'am.
Correct.
The issue.
How the various judges have decided this matter? Similar matters.
That has been taken care of in the case of also Ashok Mahapatra and other cases.
Yes. Now, Ashok Mahapatra, they said 50% of the
half, 1/3, and then 1/3, half, and
huh?
That is 2:1.
2:1.
Yes.
Means if it is 3 years, if it is 3 years,
Yes.
1 year will be counted.
Yes. But out of 2 years, 1 year will be counted.
That is 50%.
50%.
50%.
2:1. 2 years of aided service. My lord, against that, 1 year.
1 year will be
taken as
counted.
government service.
That question arises when, because the aided schools were taken over by the government.
Taken over by the state government. By
Therefore, all these things arose. Keeping in view the employees of the regular government schools.
Yes.
What do you say, Mr. Mohanty? The matter appears to be covered by judgment of Mohapatra.
My lord, similar matters has been disposed of, or else we will file the regular counter.
What counter you can find in this matter? Already matter has been decided, saying that in Ashok Mohapatra, 50% of service and taken over period is impermissible under law, and accordingly direction was given to compute the entire pre-taken period computation of RACP, and so far as RACP is concerned, entire service.
Entire period.
For seniority is concerned, 2:1. That makes sense also. What to do? You want to file objection, or shall I give dictation in this one?
My lord, I will file objection.
Very small matter.
Similar matters have been posted to some other date.
Some other date. Which date they are posted?
2 weeks after, my lord.
Call this matter along with the WP number. Give that.
23049 by 24.
23049 of
24.
24. Okay. When they are posted?
2 weeks after. Date exactly 2 weeks after.
All right.
Yesterday, item number 46.
Huh?
Yesterday, item number 46.
Yesterday is item number 43.
46.
46. Call on it. Yesterday is item number 46. Okay.
Item 53. Item 53.
53.
My lord, on behalf of Mr. S.K. Joshi, kindly be pass over.
Pass over?
Yes, my lord.
Are you ready in the matter?
No, this is all the way allotted to my learned friend Mr. G. My lord is
call next. Yes. The request of the
Lordship, may I please, your lordship?
Yes.
State was supposed to file counter in this case. Not yet.
Who appears in this? You appear or G?
No, Mr. G will appear. It is from up to 16 alone.
G has to appear. Week after next. In the meanwhile, file objection. Or week after next. In the meanwhile, after may be filing.
Public.
Yeah.
Item 55.
Yes. 55.
The notice issue is notice. Last time it is coming for filing of counter.
State has not filed counter.
But by counter, calling the first or second week of January 25th. Next. In the meanwhile, counter may be filed.
Item 56.
Yeah.
This is a selection matter. Your counter is that everything has been filed. Pleadings are complete. My lord, an advertisement was floated.
May not be possible, because I'm in the mid of dictating a full bench judgment. So my mind is little occupied that I should not do injustice to these people.
Then let it come next week.
Next week we have difficulties. We'll call this in the second week of January.
My selection matter, my lord, 2021 selection. I have been selected, but I have not been given appointment.
22nd 12. Okay.
22nd December.
December. Okay.
22nd. But there will the last week of vacation.
19, 12.
18th or 19th?
19.
Yeah.
Item 57.
Yes.
Challenging the order of transfer, my lord. You will suppose please to stay the operation of the order of transfer. Still the opposite party, my lord, did not allow the petitioner, my lord, revert back to his original post, my lord. They have today filed a complaint affidavit, which is not in order. And my lord, there is a judgment of this Honorable Court passes Switzerland and Mr. case. This type of employees cannot be transferred. The order of transfer is quashed. Entire proceeding was cast.
Interim order, you are not complied with. You are for whom?
My lord, I am for the opposite person 3 and 4, appearing on behalf of P.K. Mohanty, senior advocate. My lord, today we have received the copy. I will go through it.
Copy. They served a copy on me, my lord.
My lord, Lord, in the interim order, my lord, let me see, in the interim order, it was directed that the stay of the annex 5 and 6, my lord.
Correct.
My lord, in the counter affidavit, we have already mentioned that pursuant to the order of the
Transfer.
but in Annex 5 and 6, my lord, the officer has already joined before the interim order was passed.
Joined means joined to other school.
No, my lord.
Some other person who is posted to your school, he has joined it.
My lord, in not school, but in the office
In
of
the office of the senior Samudra Shabijat, my lords. He's joined. I admit this fact, my lord.
If we joined, where is vacancy, how to accommodate?
But this honorable court, my lord, is order dated, my lords,
directed to
7/2025 has stayed the operation of the internal because of the fact that, my lord, these type of employees cannot be transferred. There is judgment, 57th judgment of this honorable court, and this honorable court directed, if you want to make a policy of transfer, let the state government take a decision upon this and thereafter may transfer any person. That has not been done till yet. And Annex 1 and 2, my lords, clearly speaks that these type of employees cannot be transferred. May only pray, my lords. Lordship may call it next week any day. I will come with that judgment. And by Annex 41, so Annex 1 and 2 can satisfy, my lord. The order of transfer is without authority.
Okay, call on 27th. Yes.
Bless.
Item 58.
Welcome on to sir. Welcome. It's now.
Item number 70, today morning, my senior Mr. Das mentioned for tomorrow because his intervention application had not come on the board. My lord, I am also an intervener. My application has not been till allowed by your lordship, nor his allowed. But the problem is, your lordship modified the interim order. By virtue of your lordship's modification, all the department, PCM, CBZ, everybody were called for orientation tomorrow. Yesterday night, they have deleted the PET. Tomorrow is the date of orientation. They will be given appointment by the chief minister. But PET, though we were in the list by virtue of your lordship's interim order, now yesterday night they have deleted the PET. That is my problem before it. But it is not tomorrow that it will. Tomorrow I would not have any problem. But this problem is this, that if it is really, if your lordship may kindly accommodate today.
Now, can I interdict what the chief minister is going to want tomorrow?
Not that. PET that deleted, for them I have filed an intervention. All have been asked to appear tomorrow, but PET category has been deleted.
Deleted. Maybe because of the order of this court.
No. Virtue of your lordship's order, everybody have been called. But PET somehow has been deleted. That is the reason I am intervening.
Let it come tomorrow anyway. Today also we cannot pass any order. Tomorrow anyway it is coming.
Tomorrow is subject to, can I mention in the morning for taken up?
Yeah, mention it.
That liberty if your lordship grants.
Yes.
Grateful.
Your lordship, item number 61.
61.
I need 4 weeks time to file counter in all these 3 cases.
Lordship, I am for the
department side.
We have no objections, Your Lordship. May fix up some day in December and the interim orders to continue, my lords.
We will fix it in second week of January, interim order. Next.
Item 45.
Yes. Yes, Mr.
Your Lordship will recall, this is the case where the child care institution, which was receiving granting aid from 1982 till 2017-18, certainly was deprived of granting aid from 17-18, for which there was...
You were drawing granting aid from which year to which year?
From 1982 to 2017-18.
1982.
It's one of the oldest childcare institution in the state.
It's dated from 82 to
2017-18.
Childcare Institute.
Yes, my lords.
Means what?
And my lords, this is a childcare institution which is located in the tribal region of the state, in the district of Koraput. And all the inmates are orphaned tribal children.
Tribal orphans.
Yes, my lords. So, my lords,
children.
yes, my lords. So when they were denied, when they were not.
This aid was given under which law?
My lords, under the Juvenile Justice Act. Scheme is formulated by the center as well as the state. And by virtue of that scheme, the center gives the major part of it.
It is a PP.
Sorry,
participation.
Yes, Malaj. Yes. There's a scheme. There is a scheme, Malaj. Annex this scheme, which is presently named and styled as Mission Vatsalya.
Mission
Vatsalya.
Vatsalya.
Yes, Malaj. It's given different names under different regimes, my lords. It's presently styled as Vatsalya.
It is Vatsalya. Sanskrit word is Vatsalya.
Vatsalya, yes, my lords.
Yes.
So, my lords, when they were denied, when they were not given the grant in aid, before I come to that, my lords, once I am given a grant in aid, the only way in which it is to be stopped is by passing an order of suspension. That is, under the scheme, if your lordship sees annexure
4, page 49.
Page 49 of the brief, my lords.
According to you, it is a statutory scheme.
Yes, my lords. Your lordship sees.
Which section provides for that?
I'll just show. Your lordship may straightway take that gazette notification. It's at page 33. Your lordship's got page 33?
Yes, sir.
Revised guideline for granting aid to registered
JJ
child care.
Act.
Yes, it's under the JJ Act. Now, my lords, the relevant portion which I would like to bring to your lordship's attention is at page 49. Chapter 5, my lords, deals with withholding of granting aid and appeal.
Suspension or termination of granting aid.
So the director OSCPS by specific order may suspend the GIA in respect of any CCI in the event of the following. There certain events are there. Now, my lords, thereafter, your lordship.
Failure to comply with conditions, blacklisting.
None of this has happened. My lord, this provision has also not been invoked. I'm just showing to your lordship only for the purpose that once I get a grant in aid, the only way to deny me this is this provision. Now your lordship sees that after suspension of GIA, the director shall serve a show cause notice to the institution for reply within 30 days. After examining the show cause reply, if received, the director will pass an appropriate order. Any subsequent order will be issued only after necessary inquiry and or recommendation and report of the collector cum district magistrate concerned. So, well, it's in my case, nothing of this sort has happened. Neither has an order of suspension been made, nor has any show cause notice been ever served on me, nor has any order been passed by the collector saying that this institution would not be entitled to
Chapter
GIA.
5 is not invoked.
Has not been invoked, and there is no other provision under the scheme by which an institution, existing institution which is getting granting aid, will be denied that granting aid.
What they say?
Now, my lords, your lordship may kindly come to, when they denied it, I came up before your lordships. And your lordships, in the first round of litigation, which is at Annexure 2, at page 26, the orders of your lordship, the relevant portion is at page 29.
Saying, consider the submission pass.
Yes, even though the concerned authority refused to recommend the petitioner's society to get the benefit of granting aid from 1819, but has found from the communication
Anyway, within 1 month it should do that. That's
yes.
Beyond that.
No, my lords, they did not do anything. They sat over the matter. Ultimately, they passed an order which is at Annexure 1 of the writ petition. Saying that you are not entitled to.
Why?
No, my lords, we need not go into this order because they have considered before this honorable court that this order is bad, it is untenable, it cannot be sustained, which is recorded in order dated 25/6/2024 of this case.
25/6/24 order.
May I read out that order, my lords?
Yes.
Para 3 of that order, learned additional government advocate fairly contended that the order dated 7/8/23, which is impugned in the present writ petition, has not been passed in compliance of the earlier order passed by this court on so and so. Learned additional government advocate contended that in compliance of the order dated so and so, a fresh order will be passed.
After giving opportunity
of hearing. That opportunity of hearing was given, and what has emanated is Annexure 25, which I have amended to be impugned. 197C.
What thereafter they heard you and passed the order?
They passed the order, which is at page 197C.
What it says?
Now, let's kindly see that order. They have given, I'll take your lordships through that order because they have given various reasons. I will meet each one of them as I go through them. Now, your lordship sees at page 197C. Does your lordship have that page?
Yes.
Now, kindly see the columns at the bottom of the page.
Para 5.
Para 5, whereas it's revealed during hearing the date-wise of the matter which is specified below. Point number 1. The petitioner, by letter dated 15th.
Close down the child care unit.
Desired to close down the child care institution run by it at Koraput and Burja with effect from 1/4/18 due to lack of funds, higher NGO share in GIA and release of GIA. Therefore, the comment is, therefore, the DLPAC did not recommend GIA proposal of the petitioner for the year 1819. Now, this, my lord, is palpably false because when I wrote to them, they wrote back to me saying that we are not in a position to take the children. You have to continue. That is at Annexure 13. Page 144. They said that you need to continue. And thereafter, my lords, immediately thereafter, I said that all right, I will continue. That is at Annexure 13 and 14. So, my lord, the first ground which they have taken in this letter is wholly untenable. Now, your lordship comes to the next thing. However, yet again, the petitioner, by letter dated 34/18, informed opposite party number 1, this is Annexure 14, stating his willingness to continuation of the said child care institute with support from so-and-so along with fulfillment of certain conditions. Even though the DCP of Koraput had intimated to secretary for production of children before the Children Welfare Committee surrender certificate, surrender of materials purchased, etc., however, considering the willingness of the petitioner, the district administration gave an opportunity to the petitioner to run the child care institution without GIA. My lord, this is patently false. It's not borne out in the record. Such a communication has never been made by them. And such a letter has not seen the light of day despite the specific instruction of your lordship calling upon them to produce the letters in question.
Yes.
Now kindly take column number 3. Later in the year 1920, page 197D. I'm going by one by one. Later in the year 1920, DLPAC Koraput had recommended the proposal with a note that the DLPAC decided to recommend after completion of renovation work of building at Burja. Now there is no child residing at CCI Burja. We are not with Burja. We are talking about Koraput. The child care institution that is seeking aid is the
parawise comments to this.
To this, my lords. Yes, my lords. That, my lords, I have given an affidavit, which is that page.
Explaining
yes.
against each of the comments.
Flag 11.
Flag 11, your lordship may see. Your lordship has flag 11?
Yeah.
Kindly take para 3. The petitioner through the aforesaid writ application seeks to challenge the order dated 7/8/23 and the order dated so-and-so by which the opposite party has rejected the petitioner's claim for granting aid hereinafter referred to as GIA for so-and-so up to 23-24 on the ground that the proposal for sanction and release of fund has not been approved by the project appraisal board of opposite party number 7. And that the GIA is not a right but an additional assistance provided by the government to a limited number of institutions. That it's pertinent to bring to this Honorable Court's notice that the order dated 6/7/24 is unreasonable, baseless, and refers to documents that have never been produced before this Honorable Court nor to the petitioner. That in its order dated 6/7/24, the opposite party number 1 has stated that DLPAC has conditionally recommended the petitioner CCI, and for that reason the office of the OSCPS has not endorsed the name of Sarvodaya Samiti Koraput for GIA for the year 1920. It is humbly submitted that this is a clear misrepresentation on the part of the opposite party number 1. It can be made out from Annexure 19 to the writ petition that the recommendation to be made after completion of renovation work was categorically for the CCI in Burja. The petitioner CCI is located in Koraput, for which the GIA has been explicitly allowed. The granting aid recommendation for Koraput CCI has no conditions attached to it, and it is on the basis of this wrong observation and reasoning that the order dated 6/7/24 is liable to be quashed. For each paragraph, I have given a reply, my lords. Let me just run through this. That for the year 2021, the opposite party number 1 has referred to letter number so-and-so, dated so-and-so, to state that the opposite party number 1 recommended the petitioner CCI to opposite party number 7 for sanction and release of fund in favor of the petitioner. But the same has not been approved by PAB opposite party number 7. The letter referred to above by the opposite party number 1 has never been produced before this Honorable Court, nor has any reference to it been made by the opposite party number 1 before this order dated 6/7/24, despite ample opportunity being provided for the same to be included in the counter affidavit or submissions before this Honorable Court. Now, my lords, pausing here for a minute, my lord.
They say party number 7 has not approved.
That's a false statement. That's a false, misleading statement. Let me explain what has happened. My lords, I was an existing CCI. Now, there are different parameters for retreating an existing CCI and a new CCI. What the state government has done is, having not recommended my case for 1819, subsequently, they have forwarded my name as a new CCI, which is a mischief perpetrated by them. And that, my lords, is forthcoming from the documents which your lordship insisted that they produce. And they produced, and very unfortunate part, they have produced documents before your lordship which are not complete. Some pages from the documents, some selectively, but they have taken out pages from the communications and produced before your lordships. But those communications also reveal that what they have done is they have recommended me as a new CCI. And new CCI, my lord, the parameters are totally different.
Where is the difference in the scheme in question?
Yes, my lord. Your lordship. Let me show it from the PAB's minutes only.
Counter of opinions.
Counter of opposite party number 1, annexure A by 1. Get a writ petition. Yes. Kindly take page 11, running page, if your lordship sees, it's page 215. Page 11 of the counter. Your lordship has that?
Yes.
It's minutes of 246th Project Approval Board meeting held on 23/4/2018 to discuss the annual plan and financial proposal of Odisha under Child Protection Service. Now your lordship takes para number 3.
Proposal of the state.
Proposal of the state, third line. The representative from the state informed that the ink-signed financial proposal for the year 18-19 along with the utilization certificate and statement of expenditure for 17-18 under Child Protection Scheme will be submitted shortly to the ministry. It has not been submitted. Now thereafter, my lords, 3.1. PAB informed the state that statutory requirement should be given priority and any new CCI will be considered after rationalization of the homes is done by the state government. When they have not finished the budgeting for the existing school, where is the question of rationalization of new institutions? And that is why they sneak in our name after the collector and the additional district judge submit very sorry state of report saying that this institution is in dire need of granting aid, without which it is having considerable difficulty in running itself. They put in our name as a new CCI. And my lords, I have already shown to your lordship from the scheme that once I am an existing CCI, it needs to be
an order.
There has to be an order, either suspending or terminating. That has not happened. So how can you, after giving me granting aid from 1980 to 1982 till 2017-18, how in 2019-20 you can categorize me as a new CCI, which has different standards altogether? And your lordships will find from the minutes that the new CCIs are not being considered at all.
All this mistake happened because they treated your institution as the new institution. But for that, it would not have happened.
It would not have happened.
But there are some in the tables
which
they have mentioned. There are certain fault grounds also.
But my lords, that's why that was the reason why I was taking your lordship through each one of them, to show that each one of them is wrong, erroneous, not supported by any documents. On the contrary, there are copious materials which are produced before your lordships in this record, which will show that the institution is being run as per the norms, the children are being adequately taken care of, and it is in dire need of funds. That is what the collector says. That is what the
collector's
ADJ says. Yes, my lords. Annexure 24 series, your lordship sees. Page 185 of the writ petition.
Right. council senior to the something that the child care institution is treated as a new institution, and therefore the yardsticks applicable to new institution having been applied to the petitioner institution come up, the individual order purpose from ways of permit and non-application. Number two, the collector of the district concerned
and the additional district judge.
Letter
And the additional district judge, because they are to, every 6 months, they are to, every month they have to submit a inspection report.
Have recommended case of the petitioner institution for granting. In this aspect of the matter have not been duly advocated to. Where is the collector's letter?
Yes, Madam. Let me start with the ADJ's letter first.
Yes.
Your Lordship sees page 185. Page 185 at page 186, Your Lordship sees.
Where is the what he says?
Page 186 is a report dated of the ADJ dated July 2023. Kindly take page 180.
For 1 month it is.
No, every month is there. I'll show. The series is there. Kindly take page 189. 9. At the top, out of the total strength, the post of the counselor and probation officer, social worker are lying vacant. It is also brought to my notice that the institution is not being provided with any financial institution from the government since the year 1819. And that full-fledged salary of the staff is not being paid for more than a year for want of funds. Still, the institution is being maintained by the managing committee by obtaining private and hand loans on credit basis with much hardship. The Department of Women and Child Development, Government of Orissa, is to look into the interests of the children and do the needful as early as possible for proper nutrition, care, treatment, education, etc.
I have read.
Now, kindly over the page, my lords. Come to the next report of June 2023. He reiterates the same thing which your lordships will find at page 193. And it goes on and on and on. Now, my lords. Page 172. Kindly see page 172. 172 of the writ petition. This is the additional district magistrate writing to the collector, writing to the directors, recommend.
What is the relevant?
Now, before that, my lord, inspection report, your lordship may kindly see that at page 168. Kindly see the inspection report. This is the inspection report of the Child Welfare Committee. The lordship has that?
Yes.
Kindly take at page 170, the last paragraph. May I just place that? The institution is the oldest institution of Koraput district and only one CCI established in the high standard area of Koraput town, registered at the JJ Act 2015, having all facilities and amenities required for the inmates. This is a famous and renowned and reputed organization of the Koraput district as well as of Orissa, and receiving granting aid from the government to run the CCI. Everything was fair and fine, smooth and even easy and pleasant, cheerful and delightful up to the year 1718. But 2018-19, dark cloud of financial fiscal crisis hovered over the CCI as its granting aid from the government was withheld for the year 1819 without any reasonable and valid reason. When the financial plight grew more complex and the burden of the maintenance of 32 inmates became colossal, the secretary submitted an application to so-and-so on 25/5/18, picturizing the matter, and he had communicated to DCPO on so-and-so.
I have read that.
Thereafter, your lordship.
Last paragraph you can.
In this context, the addition. In the whole, the committee
They
said,
found fault with the officers that report that he should return everything, etc. No? That is faulted by the committee report itself.
it's faulted by the report. Now your lordship sees, now kindly see the proceedings of the DLPAC. That is at page 173. District level project appraisal committee, of which the collector is the chairman. Now,
what they say?
Now, serial number 3, column number 3, Sarvodaya Samiti, that is the petitioner. Kindly see, provide all-round development, child in need, care and protection. DLPSA decided to recommend after completion of renovation work of Burja. Now there is no, as far as Burja is concerned, I am not concerned, I am concerned about Korapur. Now, my lords, thereafter your lordship sees at the bottom of page 174, it has been signed by various officers, including the collector.
No, very liberal, Koraput.
That is, my lords, Koraput, first, kindly see column number 3 at page 173, Sarvodaya Samiti at Koraput and Burja, both. So I am talking, they have made 2 columns, my lords. As far as Burja renovation is there, as far as Koraput, child in need, care and protection. Now your lordship kindly take page 175, the collector, this is the collector's recommendation. Submitting the financial proposal. Page 175, your lordship.
This is by district magistrate.
This is by collector, yes, collector Koraput. Collector Koraput, there he has recommended 7 CCIs, out of which Sarvodaya Samiti is at serial number 3 at page 177. Have been recommended by the
serial number?
Serial number 3 at page 177.
Shishu Sadan,
Sarvodaya Samiti. 25 children are there, ongoing, but GIA withheld from 1819, 1920, provide all-round development to the CNPC children and protect their child rights. Children in need of care and protection.
Yes.
Signed by the collector.
This is dated?
This is dated the 25th of February 2020. Now, the letter of 2021 is at page 179. There also I am at serial number 6 at page 180. Like Say number?
In that you are not there. In 180, you are not there.
In the next one, I'm not there. Because they've been Now, one more document which I will show to your lordship, which has emanated during pendency of the writ petition, my lords. That is annexed to IA number 16274 of 23.
Come to 186.
Page 186. Yes.
Even this does not mention about you.
186.
They mention the names. It is situated.
No, 189, my 186. That's a report of in respect of my institution only. My institution, and the relevant part which I read out to your lordship is at page 189.
186 relates to where is your name?
186. It starts at 185.
It starts at 186, page 1.
My lords, 186 is the report. The covering letter is at page 185.
Sarvodaya Samiti, Koraput.
Koraput, for the month of July 23, made on 31.
You are what? Your name is?
Sarvodaya Samiti Koraput.
Shishu.
Shishu Sadan Sarvodaya Samiti Koraput. Shishu Sadan is for the children's home. Actually, my registration is Sarvodaya Samiti Koraput.
Your petition itself is Sarvodaya Samiti.
Sarvodaya Samiti. The grant aid is coming in favor of Sarvodaya Samiti. Now, page 185, your lordship sees, is the covering letter. The report begins at page 186. It concerns me only. And the relevant portion I had read out to your lordship at page 189.
Nine.
189, I read out to your lordship, page 4 of that report. Out of the total strength, the post of the councillor so-and-so posts are vacant. Also brought to my notice, the institution is not being provided with any financial assistance from the government since 1819, and that full-fledged salary of staff is not being paid for more than a year for want of funds. Still, the institution is being maintained by the managing committee by obtaining private and hand loans and on credit basis, etc., with much hardship. The Department of Women and Child Development, Government of Orissa, Bhubaneswar, is to look into the interests of the children and do the needful as early as possible for proper nutrition, care, treatment, education, training, development of the inmates.
These are monthly reports.
Every month there is a report, and every month
these reports start from which month?
Well, I have annexed only few of them. I'm not. It is there. Every month the state would be having the reports. Every month it's mandatory for under the Juvenile Justice Act for the ADM to make an inspection every month and submit a report, because these are very delicate institutions. Very vulnerable institutions, and unless and until they are monitored on a regular basis.
What is your counter, brother?
Well, it's just one more document I'll show to your lordship. Which has emanated during the pendency of the writ petition, that is annexed to the IA number 16274 of 23, which was filed on 10th of October 2023. IA number 16274 of 23. Your lordship has that?
No, I am unable to. This every flag
B, Maharaj. Your lordship takes flag B.
That IA states what?
IA states it has the latest report from the collector recommending my case. Kindly take page 11. Page 11. Submission of grantee aid proposal of 6 childcare institutions, Koraput, for the financial year 23-24. Now, kindly see serial number 6 is Sarvodaya Samiti, Koraput. And the report is on the next page. This is signed by the collector. And at page 14, they are saying that ongoing, but GIA, now kindly see the comment. Ongoing, but GIA withheld from financial year 18, 19, 19, 20, 20, 21, 21, 23, 23, 24, 22, 23. Now, my lords, on the face of this very entry of their own document, is it open for the state to categorize me as a new institute while submitting a proposal to the center?
You are reading page?
Page 11, my lords, I started. Annexure 1B.
Name figures.
Thereafter, my lords, I was referring to the column at page 14, which deals with me. Your lordship has that?
Yes.
Page 14, it deals with Sishu Sadan Sarvodaya Samiti. Leave the first, second, third, fourth, fifth column, your lordship sees. Ongoing, but GIA, that is granting aid, withheld from financial year 18, 19, 19, 20, 20, 21, 21, 22, 22, 23. On the face of this entry in their own document, is it open, my lords, for the state to submit a proposal to the center categorizing me as a new institute?
Where is that
Yes.
recommendation?
Recommendation.
Which they sent to the center.
Yes, yes. That is, they have not brought it on record by way of an affidavit. But then your,
Minutes of meeting.
জিনিসটা বলছে নিউ ইনস্টিটিউট বলে কোথায় বলছে এটা
Your first contention.
Sorry, madam.
Your first contention.
Yes.
That the first foundation for altering the position is that you have been treated as a new institution.
But no,
policy requires that new institution, the difference is maintained between the existing institution and the new institution.
Correct.
Where is that they have treated you as the new institution?
Yes, yeah. That my lords, your lordships will now flag 13. Kindly see flag 13, which is an affidavit filed by the government of India.
What they say here?
I'll just show your lordship. Yes. Kindly come to page 42 of that. Kindly come to page 42. Lordship has that?
Yes.
Column number 4, Roman 5. New proposed NGOs run CCI for the financial year 23-24. And there I am shown at serial Roman 3, Sarvodaya Samiti, Children's Home, Koraput. Now, one more very interesting feature which would emanate from this, my lords, from the minutes also, is that I have nowhere been mentioned in the minutes otherwise. The institutions to which granting aid has been stopped and the reason for stopping them have been mentioned. I do not figure there. It is as if I have summarily been pushed out of the contention. They somehow wanted to wipe me out or something. Somebody just wanted this institution to be wiped out from the zone of consideration.
Yes.
This is very bad. The two documents your lordship just takes in perspective. One is they admit that it was getting granting aid up to 17-18 and granting aid has been stopped, withheld from 18-19 onwards.
Your briefing counsel is very intelligent. She is correcting your language. When you say stop, she said withheld. Yes.
So, my lords, it was, they used this expression, it was withheld from 18-19 onwards. Having said that, it is no longer open for them to thereafter categorize me as a new institute and put me in a different category because new institutes are not being considered for GIA at this moment.
Let us see what they will say.
Subject to what they reply.
So, to summarize your contention.
First, my lords, the contention is that
right now
I was getting granting aid.
Propositions.
Yes.
Yes. Take down.
Institution was getting granting aid from 1982
to
2017-18. It was not stopped thereafter by due process as indicated in the resolution.
Action was taken for stopping the granting aid as provided Chapter 5, Roman 5 of the scheme in question. Scheme itself being statutory. First off. Subsequently, some development took place before the coordinate judge, and the government AGA agreed that the impugned order is contrary to law and that they would undertake fresh consideration of the first time. Accordingly, the fresh consideration has taken place. Next point. The institution in question would not have been treated as a new institution at all, in as much as the parameters applicable to new institutions are a bit different. First, this factor is forthcoming from IA number additional affidavit filed by OP number 7, comma, more particularly at page 42 thereof. Next point. All the jurisdictional authorities having inspected the run of the institution have specifically stated that the institution has been running with adequate number of inmates and that the institution has been in dire need of funding. And therefore, arrangement should be made for making available the aid. Yes. Then what other point?
These are essential.
Yes, sir.
My lords, kindly turn to page 144, Annex 13, my lord.
144.
My lord.
Yeah.
My lords, that is 136.
136.
Page 136. This is letter dated 15/3/2018. This is written by the petitioner to the director, Orissa State Child Welfare, the competent authority. With reference to subject mentioned above, I would like to inform you that the Sarvodaya Samiti has been running orphanage for 50 children since 1981.
Not willing to continue the program from 1st April
2018.
Yeah, let us see the content, full content.
My lord.
With reference to the above subsection, I would like to inform you that the solution the names for the issues in my following reasons we are not interested to continue the program from 1st April. We are not getting any kind of support from the DCPU, so for smooth running of the program, for all around development of the children staying with the fund project, studying 46 level is not sufficient for providing food, etc., etc. 10% contribution of the total including the salary that is quite high for our organization and we will not be able to participate. Therefore, best to take in this so this is the letter they have written. Next paragraph. London AG draws attention of the court to petitioner's letter dated 15/3/2018, page 136 of the running page 136, wherein petitioner is said to have expressed his intent not to continue the program with effect from 1/4/2018. First one, letter gives 4 reasons as to why it does not intend to continue. What was your reply to this?
My lords, the reply was, no, don't disturb.
Oh, sorry. No. I thought the question was. No, you.
My lords.
You say
the reply was
you
that
did not agree with this letter.
My lords, the reply was that, my lords, kindly see page 144.
144.
My lord.
Yes. That was annexure. Earlier one is annexure.
Annexure 11.
Annexure 11.
This is 13.
Next point. The district child protection officer, in response to the said above letter at annexure 11, has sent a reply dated 3/4/2018 at annexure 30.
We sought some 1 month time to rehabilitate the children in nearby hostels, government-run hostels.
When he expressed the inability to rehabilitate these children within short time, and therefore the institution was requested to keep these children for 1 month so that alternate accommodation would be provided.
My lords. Then, my lords,
what happened?
My lords, then, my lords, kindly turn to page 145, annexure 14.
This is from the institution.
My lords.
What is it?
They put some conditions to run the institute again, my lord. Those conditions were not accepted to the government, my lord.
They said we are agreeable to continue.
Continue provided you fulfill those conditions.
We required support from the so-and-so
Yes, sir.
posting of program, career planning for all-round development of the children staying in our so-and-so. The funds provided. This was the letter when it was 30/4/2018. 13 was written when?
My lords.
15/3.
My lords.
Not 15/3, on 14/3 you should have taken the children back.
No, my lords. So
Yes,
on
1 month you were sorry.
3/4, my lords. 144. Annexure 13 of dated 3/4/2018.
You are 3/4. Then 2/5. 1 month is over. Did you take back the children?
My lords, they wanted to run the institute.
So you agreed with their running the institution.
My lord.
Did you pay the money?
My lord.
Did you make the aid available?
Aid is not a right, my lords. I'll cite judgment. Aid is my lords, first contention was made that the scheme is made under the Juvenile Justice Act. They are getting the aid from 1982. The Juvenile Justice Act came into force in 2000.
No, earlier,
So it cannot be under.
No, there was before Juvenile Justice Act. There was another statute, I don't remember. Juvenile Justice Act repealed which act? I believe, I vaguely believe there was some even otherwise. In executive policy, you did it. We'll assume that way now. In executive policy.
My lords, our contention is that specific government is that we inform them that we will not give aid. You run on your own.
How?
My lords, this is like this. This is under a scheme. The scheme is that central government will bear 60%.
40% is
60%.
No, 30% was 10%.
10%.
PPP is
there.
60,
my lords,
30, 10.
My lords, for approval of the central government, by end of the March, it has to be submitted, proposal has to be submitted. My lords, they written in the month of March that we are not going to run the institute.
That was on
15/3/2018.
But you did not agree with that.
My lords, that is why the proposal was not sent.
No,
for 18-19, my lords, carelessly, there is no mana fide or anything, my lords. Because of their letter, it was not proposed to the central government.
Yeah.
Only central government gives us. We cannot provide also. So, my lord, 60%.
Central government has if you send a proposal to the central government, it will give you.
My lord.
Since your contention is
since they have written the letter
that we don't want to continue.
Yes, my lords. But the proposal was not given.
Correct. But you sent a letter saying that immediately, if you ask us to take 50 children, it is not possible. You give us 1 month time. After 1 month, what did you do?
My lords, within that period, they sent another proposal to run the institute.
Correct. Then why did you not send the recommendation?
My lords, it has to be sent by 30th March.
The subsequently also you can send it.
No, my lords. Subsequent periods we have sent. For 18-19, it was not sent because of this letter.
For remaining period, you are...
Yes, we have sent.
Are you paying it now?
No, unless central government pays, where from will get money?
Central government
it is under a scheme where they have not approved for 2021, 21, 22. From 23, they are getting.
All right. But when you asked them to retain the children,
my lord.
And subsequently, you did not make any arrangement for those children. You said for 1 month you retain the children. Thereafter, we will make the arrangement. Where did you make the arrangement? You are asking them to retain the children. Then entire money should be paid by you.
They agreed to run the institute. There was no contingency to take them, my lord.
No, but once they agree to run...
My lord, it is an NGO. It is an NGO. And they wanted to run themselves, my lord.
Correct. But all these years, you have given the money. That creates a legitimate expectation. For
there is a right, my lord. Where is right?
Legitimate expectation is also judicially enforceable.
My lord, it is not enforceable right. The aid is not, there is judgments also. The granting aid is not, it is only to facilitate the work. The additional benefits. It is not a matter of enforceable rights doesn't accrue, my lord. My humble submission is subject to my lord's acceptance. So, my lords,
Permits that the institution itself having expressed its willingness not to continue the claim. The government did not recommend its case for allocation of funds under the CPP, whereas 60, which is in the ratio of 60:40:10. First. Now, when you said after 1 month we are rehabilitating all the children, but you did not rehabilitate.
Because
then you put that burden on them only.
Because they wanted to run in our counter, we have specifically stated that. We have stated that if you will run on your own, you run. We are not going to give any aid.
But you agreed to take the children.
But after subsequent to that, they run the
institution. Then you should make the payment.
No, it is not automatic match.
No, this
aid, granting aid is not rights, enforceable rights.
That you have said that twice. No issue. I agree. I will take that it is not enforceable at all. Okay. Now question is, having told them that we will take back all the children, make accommodation, and having not done that, how can you put the expenditure on the part of a private NGO? When you said,
my lord,
otherwise
my lord, there is no contract or no assurance by the government. It is under a scheme. They cannot say that we are entitled to this. We have rights over this.
All these years we have given.
Aid, my lord.
But all these years you have given.
Because of their, at their instance, this problem arose, my lords. Why from 82 it was paid up to 2008?
Because central government is also a party.
Yes, ma'am.
Party. Who pays for the central government?
I am afraid. I have already filed counter matter. They have in the first writ petition before amendment, they have claimed for continued for the year 2018-19, 2021. In our counter, we have specifically mentioned that we have not received any recommendation for the years.
From the state, you have not
from the
received
state.
Suppose if the state sends the recommendation, will you consider?
Then it will be considered matter.
Where have you stated in?
We have not stated that. We have stated that we have not received any recommendation from the central
What is your
state government.
how many grounds you have?
At page matter 202, para 9.
What is that?
It is explained somewhere that so far as the Ministry of Women and Child Development is concerned, funds have been released to the state government of Odisha for the petitioner organization Sarvodaya Samiti on recommendation of the state government for running children home in the district of Koraput for the financial year 2014-15, 15-16, 16-17 and 17-18. And thereafter, the state government has not recommended the petitioner organization for continued under Child Protection Service scheme. Now, Mission Vastalia scheme, the project approval board of the Ministry of Women and Child Development considers the organization only those are recommended by the state government for release of grant. As the state government has
the only
yes, madam. Thereafter, madam, pursuant to this affidavit, this Honorable Court directed that whether you have received recommendation or not, to clarify this matter. This
says no.
Yes, madam. Thereafter, we filed another additional affidavit. On 13/10/2025.
Council draws attention of the court to the counter affidavit filed by line to the effect that since the state government had not sent the proposal with recommendation for the year 2018-19, the allocation of funds to the extent of 60% was not made by the central government. What in the additional affidavit?
2018, 19 and 19, 20 also.
18, 19, 19.
21.
Yes.
Thereafter, my lord, we filed another additional affidavit
Saying
on 13/10/2025 at para 6, my lord.
What do you say?
Para 6, my lord, we have stated that the PAB approved, my lord, from the bottom, 10th line, para 6, 10th line.
That in the similar manner.
The PAB approved the name of the petition organization for running of children home in the district Koraput of Odisha for finances such and such. However, it is reiterated that the name of the petitioner organization was not recommended by the state. Such and such, my lord. Thereafter, para 7, my lord. The name of the petitioner organization in the financial year 2020-21, 21-22, 22-23 and 23-24. However, the name of the petitioner was not approved by the PAB for the said financial year.
PAD means?
My lord, project approval board, my lord.
It is from which central or state?
It is central.
Central?
Yes.
Whom it comprises of? Who are the constituent members of the board?
There.
Lordship will get that at page 200, 220, 219 and 220. The constituents. This is the Women and Child Welfare Department Secretary is the Chairman, Central Government. Additional Secretary, thereafter J&S and FA, Integrated Finance Department of Ministry, Joint Secretary of Child Welfare Department, Joint Director of NIP CCD New Delhi, Under Secretary CWD, Mission Director of CPSU, Project Implementation Officer of CPSU, and Accounts Officer. And thereafter, the state government also is represented by Director ICDS and the Program Manager of SCPS.
No, CPSU means?
CPSU is Child Protection. Let me just tell you.
And MWCD?
MW is Ministry of Women and Child
Development.
CPSU is Child Protection in something.
CPS.
Unit. Yes, stands for?
Services. Child Protection Services. CPS.
Child Protection Services.
Yes.
Child Protection Service Scheme.
What?
Child Protection Service
Scheme.
Child Protection. This is CPSU.
So Child Protection Services Scheme.
U is what?
U is
Unit.
Anyway. Your affidavit is filed on which date?
13/10/2025.
Brother Behra,
Balance.
your additional district magistrate, additional district collector, and the additional district judge, they recommended that it has been running and therefore necessary action has to be taken. What action?
We have done our duty, my lords. We have recommended
to central government,
my lords.
When it,
except 18-19.
We'll leave that 18-19 now, assuming that the petitioner is
yes,
part.
yes.
But for rest of the years, what has?
Yes, we have recommended.
You have recommended. Then if the recommendation is there, why central government has not released?
They have not acted.
What you have done, brother, after recommendation by the state?
It has been reflected that since the PAB has not approved, that's why the granting has not.
No, why it did not approve?
I have to take instruction of.
Again, no instruction after 1 hour, more than 1 hour.
It has not been the.
No, why did it not approve? That body did not approve is your version. Why it did not approve? What is the ground? Where is the non-approval?
It is there is the PAB meeting also, minute of meetings.
That board also you appear.
But in that minute of meeting, it is not stated regarding what is the cause.
No, should you not ask him? Why, if they send central government is working like a postman, you should have asked him. You are not approving. What is the reason as to why you are not approving? It has been functioning since 1982. Till 2017, we have given to that. If all of a sudden, if we do like this, the children would be put to prejudice. Suppose if they do not look after the children and children commit suicide, who would have been responsible for all that? You are treating them worse than war criminals.
At page 44, there is a clause. State was also requested, and at page 44 of my affidavit, state was also requested to update the information of missing and found and match the children on the track child of the portal. There is
your application for impossible for me to understand English.
There is
where I will read that. Come on, which is that paragraph? Page.
Page.
Very
44,
objectionable way of treating institution of the kind. It is looking after the children. Children belong to the downtrodden community. All through you have been the money till 2017. In 2017-18, they said we are not willing to continue. But you did not agree with that proposal. You said within 1 month, we make alternate arrangement for rehabilitation. You did not do it. And you say, no, then they changed their stand that they would continue. If they continue, your stand also should be consistent with the previous stand. Where you would.
My lords, the proposal is to be submitted by 30th March.
30th one, I understand we have 2 years already.
Yes, my lords. And for the next year, we have recommended, my lords.
They have not.
Yes, my lords.
They have recommended me as a new institute. That is the mischief.
Problem is that. Mr. That although not all recommendations are sent for the year 2018 and 19 and 19 and 20, for the subsequent year, recommendation was made to the central government. First time. My learned counsel, Mr. Senior Advocate, Mr. Mukherjee, advised the spring and tells that the recommendation is effective in as much as the institution was treated as a new institution when it is as old as mountains. Yes. If it is a new institution, a whole lot of procedure will be different.
My lords, from the recommendation, there is no, since it was not continued, again proposal was given that it is for to consider it as new, it is not there.
No, it is there. I have noted it in some paragraph. I have noted the page. Page number? Mr. Mukherjee, you pointed out that page, where they treated it as a new institution. Existing and 189. Page, kindly come to page 189. You are right. Not 189. There are another page you have shown now, Mr. Mukherjee.
Yes, that was page 42. 42 of that affidavit filed by the.
Page 42. New proposed NGO runs CCIs for the year 2023-24.
That is at page 42.
42 of that.
Central government's second counter.
Second, okay. OP number 7.
OP number 7.
Yeah.
And it is also borne out from the letters which the state government has submitted without an affidavit. Certain documents they submitted on the insistence of your lordships as to what are the documents on the basis of which you have passed the order. That is the second impugned order, Annexure 25. On your lordship's insistence, they produced those letters. Now, those letters are incomplete letters. Full documents have not been given. And even those letters will reveal that I am being recommended as a new institute, not as an existing one.
Further, my lord, at 42 clause VI, kindly have a glance. 42 page of my additional affidavit, at clause VI. PAB has in principle agreed for proposal of NGO run CCIs existing or newly approved submitted by the state government. However, final approval would be given after scrutiny of the document and inquiry if required. Further, PAB has directed the state government to scrutinize the documents of NGOs such as background with respect to activities being carried out by NGO, police verification, registration on Darpan portal of NITI Aayog and FCRA compliance of NGOs. Complete set of papers to be provided to ministry. State government has to furnish certificate duly signed by the competent authority in respect of the above mentioned facts to the ministry within a month time in order to release the granted these CCIs under Mission Bastille scheme. Perhaps those approvals are incomplete.
This was addressed to whom?
And this is the minute of the PAB meeting, my lord.
Government.
2023. This is the minute of meeting by the PAB, my lord.
And they did not send any reply to this. What is the reply, Mr. Behura, to this letter of the central government? What is your response to this letter of the central government?
My lords, that is.
CBC draws attention of the board to the central government letter dated 23/6/2023.
And this is the minute of meeting.
Address it to the Secretary, Department of Women and Child Development, Government of Odisha, wherein at internal, at para 4 into bracket Roman 6, small 6. Internal page 2, that is page number 42 of its additional counter, additional affidavit, like 13, reads as under, stated as under. First, where is your reply to this?
My lords, for 2023, it is related to 2023-24. They are getting the. They are getting the.
No, otherwise they would not have been here at all.
No, my lords. The prayer is for 19, 20, 21.
2021, all right.
Yes.
But subsequently, one development happened because before the learned single judge, you agreed that this is wrong order, we'll pass another order. Then you have passed another order. Thereupon that this petition is structured this way. You are dealing with not the war criminals, but the children belonging to downtrodden.
My lord, it is so big a file.
Of course, I understand.
In the night 10:30, we get this file.
These problems I have been seeing with your bar members. They do not make form notes. Form note should be made. It should be only one form. Everything with small letter. Very immediately you can.
My lords, I have done that, but it
is bigger. What is the response to this letter?
In each minute of meeting, there was a direction to the state government. In each meeting. In also 2020, 21, 22 also there was a...
That is a formal...
in my...
Any complaint of any kind against the institution in question? Any illegal activities, child abuse, or any child suffering, death, etc. Nothing like that. Appears to be a genuine institution.
But the dispute arose on their fault, my lords. Otherwise...
Because of that letter.
Yes.
That letter, all right. But for a subsequent period, at least we should have done. 2000, letter was written in 2000, in March 2018. 2018. 15/3/2018. And to that you sent a letter reply on 7/4/2018. You said that you will retain them for 1 month.
3/4.
3/4, correct. 3/4. You said that within 1 month you will make alternate arrangements. But you did not do. And your answer is that no, they changed the stand and sent another letter on 17/4. But question is, if they had changed the stand, then their status as old institution, existing institution is restored. That way it should have been considered. Your officers recommend it mindlessly that it is a new institution. All problems arose because of that. Even then the central government said, if you do this exercise, we will make the grant available.
I should kindly have a glance to page 28 of my additional affidavit. Para 7. Para 7.
There are 7.
Whereas sufficient funds are also there. The state informed that the state has an unspent balance amounting 416.61 lakhs as on 1/4/2021, which may be revalidated for
21-22.
May be conveyed to the state that there is no need of revalidation of unspent balance lying with the state government during current financial year 2022, provided the unspent balance is being utilized for the purpose it was sanctioned during previous.
My lords, for the purpose it was sanctioned means for the purpose it was not sanctioned to pay the petitioner, my lords.
No, it was for that purpose only.
No, my lords. Against each CCI institutes, there is a sanction. We cannot utilize one sanction money in another's account, my lord.
No, if that were to be so, you should have written a letter to them. You have written like this, sir, now we want this money, kindly permit us. It is not that central government has not given the money. Center's money, about 4 crore is with you. You have written that money and put it under the pillow.
So far, treating this as new, in our recommendation, it is not there.
No, that is not.
That is
by Mr. Mukherjee, na?
My lords, page 18.
Mr. Desai contained that grant in aid is not a matter of right, and therefore writ petition is not repayable. Learned CGC, Senior Panel Counsel appearing for this government draws attention of the court to the fact that more than 400 lakh rupees are lying with the state, and that the same can be utilized without any further sanction command for the purpose for which credit is made.
My lords, my submission is that it is a purely money claim. It cannot be determined. There is no quantification claim, my lords. In absence of such quantification, this cannot be adjudicated in a proceeding under 226, my lord.
Where he should go?
He should go. Common law
No, he is not on quantification at all. No. He only says, you recommend my case for allocation of funds in 60, 30, 10.
My lord.
Treating me as an existing institution. Rest of the things will follow in accordance in normative process. That is the only case. Even such cases should be sent to this.
My lord.
Here, this is a totally misconceived. There is no question of quantification. Quantification has already been done by the collector. I don't do it. They do it. It has already been done. It is there in the record. He should have seen that record.
Even the dispute is not about the quantification at all. Dispute is about the entitlement. Once the entitlement is fixed, things will fall apart.
My lords, the contention is that we have treated that as new.
Yeah.
It's not borne out in the record.
There, brother. I'll show you.
My lord.
Which is that paragraph for Mr.
Page 42. That's the
scheme, my lord.
42 of 13. No, you
Track 13 is the minutes. Like minutes of the PAB. This is additional affidavit filed by the opposite party number 7 on the 10th of October.
13 October.
13th of October, yes.
Kindly come to page 42 of his affidavit.
That is my submission, man. There clause VI.
Page 42 of his additional affidavit. Additional affidavit.
Yes, ma'am.
Additional affidavit. In that Roman 5, new proposed NGO run CCIs for the financial year 23-24. PAB did not approve the NGO run 6 children homes. So and so. There is Sarvodaya Samiti children home at Koraput.
Well, your lordship may also see the documents which the state government had submitted to your lordships. This is the letters. Your lordships directed them to produce the letters. They produced a set of letters which is given by the additional director to the Advocate General, which was shared with us as well as the court. Kindly see, the very same minutes are also enclosed here.
Is it not the privileged communication?
They had provided it. They are the ones who had given it to the court and to a copy to us.
Is it pursuant to any order?
Yes, pursuant to your lordship's order.
Which order? Otherwise, I cannot look it.
Yes, your lordship, I'll tell you.
There was an order, man.
I'll tell your lordship the exact order.
To produce those documents.
16/1/2025.
If privilege is waived, then we can look into
16/1
communication between lawyer and the client.
16/1/2025, this honorable court made an order that all the letters that you have referred to in the impugned order be produced.
Mr. Mukherjee draws attention of the court to a coordinate bench order dated 16/1
2025.
2025, wherein a direction was given to the state government to produce all correspondence that has been referred to in the impugned order, and accordingly, some are produced. One of the letters is dated. These are produced before me also.
Pursuant to that order also, we have filed this affidavit.
And the very same document, it has come from the state as well as from the center.
19/8/2025, addressed to the Advocate General. And it is accompanied by what you want to show by
the very same document, which, my lords, is at page 42. That very document is also given by them. And the unfortunate part is they have not.
Those minors have been communicated to the department.
No, it's an incomplete document which has been furnished, but that way, this also finds place there.
where is this document? In our file.
In fact, they had filed it on that date. They wanted to file. They also undertook to bring it on record by way of an affidavit, but it never came. The documents were filed. Only the documents were filed.
They have recommended case of the petitioner in one document.
Yes.
You consider.
We also agreed to that, madam.
Huh?
We also agreed to that. We have received the recommendation, but PAB has not approved.
That I want to know.
At page 41, madam.
PAB did not approve because it proceeded on the assumption that this is a new institution.
No, madam. There are certain latches, madam.
What are?
Madam, kindly have a glance to page 41. 41 of my affidavit. Para 3.
Your affidavit.
PAB discussed. Yes, madam. PAB discussed the proposal and advised the state government to ensure the following. But these are the. This has to be provided.
Certificate.
Upload the utilization certificate and state of expenditure on portal of Ministry of Women and Child Development. We will also advise the state government to ensure the following under single nodal agency account as per instruction issued from time to time by the Ministry of Finance. Entry of legacy data into PFMS, interest accrued on balance amount of the central share to be deposited into the Consolidated Fund of India, mapping of implementation agency into PFMS as per scheme name, state to open corresponding budget lines under the mission.
To cut it short, my lords, all these things.
These are the formalities.
The state says they have recommended.
My lord, sir.
So if the state has recommended, state has obviously done all these acts and then recommended.
No, that is, my lords, kindly see letter dated 37/2020. In that bunch you have filed as additional documents.
37/2020.
My lord.
For this, if I write this order, I do not know how I am going to write this.
My lord.
With so much.
Well, it is not. So far, Sarvodaya Samiti is concerned, the child care institution.
Which document you are referring to?
My lords, this is letter dated.
You give full set of documents, whichever you want to refer.
My lords. I am doing.
No, these deficiencies, so-called.
No, it was complied. It is seen from this letter.
It is complied.
Yes.
Have they replied to this letter?
Now it is recommended for support under CPS by the district administration. The agency is registered in NGO Darpan portal. Police verification on background of the staffs deployed in the institution is conducted. Security measures including installation of CCTV, deployment of security personnel is complied. The institution is inspected by District Inspection Committee regularly.
Pass on that letter. Do you have a copy of that extra copy with you?
Extra, I don't
Isn't that bunch which I had shared with you?
Where is that bunch?
Those documents have not supplied to us.
In this only? No, that, in this, do you see that in this, is it a bunch of the letters addressed to the Advocate General?
Yes, sir.
No, front page.
Front page.
25/6.
19/8. First page. No, not that. You are seeing another letter, another bunch of letters. Just Mr. Mukherjee, find out which is that letter. Where is that letter which the AG is referring to? Kindly look into this and you that crucial letter. You say that you have complied with all the conditions and you have supported the case of petitioner.
My lord, we are not supporting for that particular.
For that, what 2 years I can understand. I can tell Mukherjee forget about that money. But what about for the rest of the years? Is it a registered society, Mr. Mukherjee?
Yes,
your client is a registered society under the 18.
Under the society is rich people. It's registered under the Societies Registration Act. It is there in the Juvenile Justice Portal of the Government of India.
In 2015, they are registered under the Juvenile Justice Act.
Correct. The act itself came belated. The Act came into was an act.
2000. It was amended in 2015.
And prior to that, there was a child care. Juvenile Justice Act started in 1986.
That's what. 1986. Correct.
Even prior to that, there was another
statute by center.
Yes.
Earlier to that, some
child care institute, child protection or something.
Something like that.
They have been getting granted from 82.
82 to 87. 86. 2017.
17.
Yes, sir. Yes, sit down. Sit down. Others, I am not sure that I will be able to touch your matters. Therefore, you need not wait, need not disturb me also. Yes, give the
I have one passport matter. Take a look tomorrow.
That passport matter.
So they are in the file with council.
You want to file counter in that? Next week we'll have that. Next week.
Item 64, my lord.
Other side.
Next matter is item 89. They are required to file a counter. I'm waiting because of, so kindly fix a date so that let them file the counter for the matter can be disposed of. But covered matter also only delivered government. And the interim order to maintain.
In all matters, wherever interim order is there, continue the interim order and call in the second week of January.
Item 65, Lordship.
Open to them to file.
Item 65, Lordship. Kindly take up this matter tomorrow, Lordship, because there is an urgency. It is a cash certificate matter, Lordship.
Why cash certificate so urgency for cash?
Actually, Your Lordship, the petitioner has to submit the cash certificate in the counseling coming in the next week, Lordship.
Okay. Cash certificate matter. Serial number?
65, Lordship.
Take it tomorrow.
Item oblige, Lordship.
43 matter pass over item.
Rest of the matters all after. Okay. Take it.
My Lordship, item number 66.
Petitioner, the child care, a registered child care institution is knocking at the door of the board for assailing the order dated 7/8/2023 passed by OP number 1, whereby it claims for granting aid for the years 2018-19, 2019-20 and 2020-21 has been negative on the ground that the proposal for sanction and release of fund has not been approved by the project approval board, which happens to be OP number 7 in this case. First off, learned senior advocate Mr. Mukherjee, appearing for the advocate on record for the petitioner, seeks to alter the decision on the following grounds. Number 1, the petitioner institution has been running with the aid effective from 1982 to 2016, 17, 18. And therefore, abruptly, aid could not have been held, stopped. There be no reason nor rhyme for the same. Kindly be seated. He draws attention of the court to paragraph 5, Roman 5 of the scheme in question, the Vatsalya scheme in question, wherein a procedure has been normed for withholding, suspension, or discontinuing of the aid. First one. Next paragraph. Before the coordinate bench, the government having admitted the unsustainability of the impugned order, had undertaken to do the exercise de novo, and accordingly, the same having been done, no relief has been yielded to the petitioner. Which is that order?
25, Annexure 25.
This order is dated
6/7/2024.
6/7/2024, a copy whereof is later produced as Annexure 25. Can you be seated? You need not to stand. 2020. First one. Mukherjee adds that the 2025 means the tabular column, etc.
Yes.
Each of the tabular column content is faultsome, and therefore the same is liable to be struck down. Next one. The foundational fault of the respondent's state, is in recommending case of the petitioner to OP7 board as a new institution as against the existing institution, and therefore the whole lot of problem arose.
May I interrupt? And the OP7 is not the board. Board here not a party. It is the ministry. OP7 is the ministry.
You can say to the central government.
Yes, sir.
To the central government. At least the board ought to have sought for clarification from the state as to whether the institution in question is an existing institution or a new institution, since material was available on record as to its being the existing institution. Next one. The petitioner had a legitimate expectation by virtue of the long and consistent stand of the OPs in extending the aid under the scheming question in the proportion of 60:30:10. That is, central government, state government, and the institution concerned respectively. And therefore, abrupt stopping of aid is violating of, is offensive to the legitimate expectation. First one. He also tells that the state government, having produced the letter correspondence pursuant to the order dated 18/1/2024. Order dated? What order? What directed production of a document? 16/1/2024. The review, the same review, a host of errors that become demonstrable by the perusal. First one. Therefore, he seeks indulgence of this one. Next paragraph. After service of notice, the state and the central government and the state government, having entered appearance, have filed their counter affidavit resisting the petition. First one. The senior panel counsel appearing for the central government submits that since the board did not recommend the case of the petitioner, it It's a stand that cannot be altered. First, he also points out that about 400 lakh rupees, 400 lakh fund, 416 lakh of rupees are lying with the state government, and that it was specifically made clear that the same can be made use of without any sanction, for the purpose for which the said funds have been placed at the hands of the state government. First, he also points out that to the certain queries, the state did not come forward with the clarifications or explanation. First one. Next paragraph. Learned AGA, Mr. Behura, appearing for the state and its officials, resists the petition, contending that the grant in aid is not a matter of justiciable right, and therefore petition is misconceived. Disputed facts relating to the claim for money are involved in the petition, and therefore petitioner should be relegated to the suit. The petitioner, while his letter dated 4/3/2018, 15/3/2018, had told the state government that it was not ready and willing to continue the institution, and therefore arrangement should be made for rehabilitation of the inmates. Third, accordingly, which officer sent the letter and date?
Page 144.
Who sent that letter?
District Child Protection Officer.
Accordingly, the district child protection officer of the state government, why the letter dated 3/4/2018, having agreed with the proposal, had requested the institution to retain the children for 1 more month, and thereafter the accommodation by way of rehabilitation would be made. First off, because of this letter of the petitioner, no recommendation was made to the central government for allocation of the aid for the year 2018-19 and onwards. First, he also does not agree with the submission of petitioner's side that at any point of time, the case of the petitioner was treated as a new institution vis-a-vis existing institution. First, he points out that the case of the petitioner was recommended for the years 2021,
20 to 21 onwards.
22,
20 to 21 onwards.
2021 and onwards, which the central government has not favored, and therefore no blame can be laid at the threshold of the state government and its officials. First, next paragraph, so contending, he seeks a dismissal of the writ petition. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. Number one, petitioner institution has been registered under the provisions of Societies Registration Act 1860 and thereafter under the provisions of JJ Act 2000. JJ Act is
16 and then 1986 onwards. It was initial until 1986.
1986.
And then
86.
Then 2015, man.
Then 2000.
The JJ Act, they were registered in 2015.
JJ Act is 2015.
Amended Act.
2000 initially, then 2015.
JJ Act 2000 as amended in time to time. First, the registration under the JJ Act, Mr. Behera points out, is in the year 2015. First of all, there is no dispute as to the institution being run with how many children?
50.
With 50 children.
Then 50, now
Strength is 50, but
now it has come to 25.
Sanctioned strength of 50.
But
that would belong to the downtrodden classes of the society, namely scheduled tribes and scheduled castes.
Yes.
Scheduled tribes. Scheduled
No,
tribes.
4 are scheduled castes. 4 students are scheduled castes, namely scheduled tribes and scheduled castes. Presently, the institution has 25 inmates. 25 inmates. First, it is also not in dispute that from the year 1982-83 to the year 2018, the institution has been granted the aid under the scheme, under the Vatsalya scheme, uninterruptedly. First of all of a sudden, how such an aid would have been stopped or withheld remains a mystery wrapped in any form. Personal. Mr. Mukherjee writes in telling the court that under Chapter 5 of the scheming questions, a procedure has been prescribed for suspending, withholding, or rescinding the grant in aid. And that the same having not been followed, the impugned orders are unsustainable. Next slide. The vehement submission of Mr. Behura that the problem began because of the letter dated 15/3/2018 made by the petitioner expressing its unwillingness to run the institution in question. First off, the said letter being short is reproduced for ease of proposal. First off. Next paragraph. No, add to the same. The District Child Protection Officer, wide reply dated 3/4/2018, responded to the said letter, which is self-explanatory. And the same reads as an. You know that. The submission of Mr. Behura that this letter created the problem is a bit difficult to countenance for more than one reason. The said letter dated 15/3/2018, although had expressed unwillingness to continue the institution, that was not end of the matter. The CDPO responded to the effect that the children would be accommodated, and for that, the institution should look after them for 1 more month. First time. Thereafter, petitioner sent another letter dated where is that letter? Where you said
34/2018. 34/2018.
34/2018. Specifically giving the reasons why it was not inclined to run the institution. First one, the intent and content of this letter shows that the petitioner was willing to continue the institution, but the difficulties were mounting up, which the state should address for easing the same. First of all, the said letter reads as under. Next paragraph. The state government, pursuant to order dated, interim order dated, date number January 2018. No, 24.
25/6/24.
25/6/24 had directed the state government to produce
Sorry, Your Lordship. 16 January 25.
16/1/2025 had directed the state government to produce the letter correspondence which has been referred to in the impugned order dated 25/6/2024, correct?
Yes, Your Lordship.
25/6/2024 in a tabular form. That is in a tabular form, which is in a tabular form. Accordingly, the state has produced oneness, ONES. The letter dated 7/3/2020 addressed by the additional director OS CPS had submitted the proposal under CPS for the financial year 2021, specifically requesting the central government to consider and approve the proposal for grant in aid. Grant in aid. First off, The said letter reads as under this. This is putting it like this. Okay, so that it becomes easy for you to dislodge.
I apologize, Your Lordship. The tabular form order is dated 6/7/2024.
6/7/24.
Yes, Your Lordship.
6/7/2024. One more sentence to be added about where state configuration. State says 1 month due, 1 month for rehabilitation, etc. After 1 month, the state did not take the children for rehabilitation and had left the same with the care and protection of the petitioner institution. First off, in the changed circumstance, because of petitioner's subsequent letter. Next point. The vehement submission of learned senior panel counsel appearing for the OPs that the state is having central fund of rupees 416 lakh earmarked for the project in question.
Unutilized. Unutilized fund.
Question, which was left unutilized, and therefore the same can be made use of even sans any sanction from the central government, shows the fair stand of the central government in the matter.
Another point is there. At page 23.
1 second. The same is in the additional affidavit filed by OP number 7 on
13/10/2025.
29/4/2024.
No,
13/10. Release 29/4/24. Code C. Deputy Registrar JE High Court 24. Where is that? Not this. No, it is what you said.
13/10/2025. Additional update.
13/10. Oh, this is rejoinder of it. In the 13/10/2025. 2025. Wherein paragraph number? Which is that paragraph? Which?
Page 28, para 7.
That para 7. It is stated as under. Let's just look into this.
Another important point is there also, madam. At page 23 of that affidavit, para 5. During the PAV meeting, Secretary WCD directed that state government should submit utilization certificate and statement of expenditure for 1920 and for grant of release up to September 2020. The granting aid will be released only after the previous grant is properly utilized, and the state must ensure that funds are not parked with them. It has also been directed.
He also draws attention of the court as paragraph 5 of the affidavit.
Yes, ma'am. It is PAV meeting 15/10
of
PAV meeting.
Minutes of supplementary project approval board meeting dated 15/10/2020. At annexer?
That annexer A/7 series. Annexer A/7 series.
Which reads As I said. Whatever information the center had sought for, it was the bounden duty of the state and its official to furnish the same so that the funds are allocated for running the institution in question, which has been doing human service throughout. First of all, it is not the case of anyone that there was any complaint against the petitioner institution whatsoever. First of all, whatsoever. Next paragraph. In the above circumstances, this petition succeeds. 7. A writ of certiorari issues, quashing the impugned orders dated. 2 orders.
Yes, Your Lordship. First one. Sorry.
24 order.
2 orders you have to, huh?
The second order is, Your Lordship, 6/7/2024, and the annexure 25. And the first order is at annexure 1, which is 7/8/2023.
Impugned orders dated 7/8/2023, 2023, and
6/7/2024.
Impugned orders dated 7/8/2023 and 6/7/2024. 2024. First off, matter is remitted to the portals of OP number 1. OP number 1.
One, my lord, central government also should do.
State government do it, na?
That money is there or not?
Money is there already. They themselves have said
they have filed affidavit.
OP number 1 for consideration afresh after giving an opportunity of hearing to the petitioner within a period of 4
They have already considered. There is nothing else to be considered. They have to release the grantee date.
Straightway, how can we make that will be bit difficult?
My lord, twice they have considered and twice they have passed orders for which the petitioner has had to come up before your lordship. And in fact, in the meantime, because of the dire straits that the institution... Just a minute, allow me to... because of the dire strait, I had also made an application that provisional grantee date be provided to me for my sustenance. Because that is exactly what...
We will do that thing. Let them consider this.
Yes.
In the meanwhile, provisional granting name with for the present current year be furnished to you.
Immediately. Within first, let them furnish that first and thereafter the hearing.
Your lordship may grant 8 weeks.
8 weeks. All right, I'll give you 3 months. But in the meanwhile,
yes,
you should continue. I'll give you full 3 months. OP1 for consideration afresh in the light of the extant policy and the documents produced by the petitioner himself within an outer limit of 3 months. Let it be, it makes no difference as long as you are given provision.
I'll again be pushed back to this court.
No, the other thing I will give you. I will give a direction to provide you the provisional grant now.
That's exactly what I've been doing since 2020. I came here for the first time. Your lordships relegated me. I again came here in 2023. That was again faulted. I was again sent back. And this is the 3rd round I'm fighting. My lord, child care institution, can it survive? My lord, I might better close down, my lord.
Mr. Mukherjee, I understand. But once if I make that order, my only anxiety is it should not be stayed on the ground that court itself would not have granted. That is the one anxiety. Anyway, if you say it should be that way, I will make that way one.
But it should be that way, my lords. That's what my humble.
My lords, what I am.
No useful purpose will be served because throughout you have taken the stand
my lords,
that he is not in.
My lords, what I humbly submit, my lords, they have to calculate as per the present strength and other things. That is necessary for consideration.
No, there is calculation also. It of such issues. Crashing the influence, so coupled with a writ of mandamus to sanction and release the granting aid for the period 2018-19 and onwards.
My lords, may make it 19 onwards, 1920 onwards. That year was
19 and 20 onwards. 19 and 20 onwards. Within a period of 8 weeks. This within a period of 8 weeks.
Your lords, make it 3 months later.
3 months. 3 months. 3 months. Failing which delay would carry interest at the rate of 9% per annum. Per annum.
My lords, in view of the concession given by the central government, because tomorrow they will say.
One more ground we have to put above. Ground. Mr. Mukherjee has drawn attention of the court to the periodic reports filed by various authorities, including the district magistrate, the district collector, additional district collector, and the additional district judges in terms of the policy guidelines to the effect that the institution has been running perfectly and that it is in dire need of the funds. First of all, they have all in some of the reports, they have also mentioned about the children being very happy, which they learned on interaction with the said children. First of all these aspects have not been looked into by the jurisdictional authorities while making the impugned orders. And that also constitutes another infirmity with which the same to suffer from.
My lord, opposite party number 1 may solicit any information and they should provide.
It hardly needs to be stated that it is open to the OP number 1 to solicit any information or document from the side of petitioner or from such other departments as are required for accomplishing the mandate scripted above. And the petitioner and other the department shall fully cooperate in accomplishing it. This is the broad linguistic. It will undergo some change after that. But Mr. Mukherjee, you are a very persuasive lawyer, as Mr. Behura and your central government council. But he was very fair in saying, we have done our job. The rest of the job is to be done by the state government. And one sentence.
That's harder to mention.
Not justiciable. He said it is not a right. That you read. Behura's contention that the grant in aid is not a matter of right is true as a broad proposition. First of all. However, a host of factors would figure when the same may metamorphose into a justiciable right, as has happened in this case. First of all, one such factor is the long and uninterrupted allocation of fund for running the institution in question under the subject of policy. First of all. Secondly, the petition is not for allocation of the funds, but it lays a challenge to the faulty decision as to why under which the allocation was stopped abruptly. There is some difference. If I seek allocation now, you are right in saying no right at all. But once you give for long period and thereafter you disrupt, then other considerations will be. That's how Wade on administrative law treats the subject. It's a very wonderfully matter is treated, in fact. Krishna may be knowing. Yes. Yes.
My lords, there are two judgments your lordship may look into. That says granting aid is not a right. One is Supreme Court, another Punjab High Court.
Yes. Okay, thank you so much.
Prior to my